not to press the matter, madam. He has got relief.
Now, the counsel appearing for the petitioner had submitted that he is under instructions not to present the writ petition in the present form. Accordingly, writ petition is closed. Mr. So appears for the Education Department.
Highly.
May I please? I did mention item number 38.
38.
Yes, Lordship. Hearing matter, old matter, my senior age bottom today some difficulty, Lordship, is suffering for fever, Lordship. So I prefer only today accommodation. Mr. Age bottom.
He is appearing. Acha, okay.
Lordship.
Although this matter relates to the year 2019 and has been taken up in the hearing column, a request has been made on behalf of Mr. S. Bothagul, Learned Counsel appearing to the petitioner for an accommodation today. Accordingly, list this matter again on hearing date. Hearing day? March now, April date. Huh? April date. Yeah, April. 19, huh? 9th of April.
Deep levels.
May I please, Lordship?
Yes.
It's a little bit accommodation for item number 11, Lordship.
11.
Lordship, part of matter, yes, thus is appearing for higher education, Lordship. There's some personal difficult stuff.
Oh, but this is, you have to inform the other side, yes, sir.
Yes.
This matter was made part heard on by the earlier order. Today, an accommodation has been sought for by the Standing Council for the Higher Education, which is not objected to by the Learned Counsel appearing for the petitioner. Stop. The last list. When was it last listed?
Last.
Section 11 number to last date to cases.
Last order.
তারপর 2 দিনের ভিতর দিদিও 28 January ছিল না এটা হলে তো 17th দিওক 17th
March.
My lord.
February. If it is part heard, I have to.
Yes.
17th, some problem is there, my lord. Can it be on 16 or 18?
Let it be on
Motion days.
Let it be on 24 or 26, madam.
24th.
Yes.
Oh. No.
থাকো 24th পাঠা রিলিজ করে দিন যদি নরো পাঠা রিলিজ করে দিন
24.
সবকে কোটে কোমোডেট করে দিন
26
হলে দিছি
My lord, 24. Any cases fixed already, madam. 26.
26th এর কেটা আছে হ্যাঁ 26th.
Yes, madam.
26th. If it does not happen on 26th, I am releasing it. I will not carry it more than 1 month. I am trying my best to accommodate everybody, trying to listen up matters in admissions everywhere. Even after that,
No, we'll try. Yes, no, we'll try.
I release it from part of.
No, we'll try to finish.
Yes.
May I please? With regard to item number 32, my lord.
32.
My lord.
Yes.
Infectious.
Eh?
Infectious. Because of
The Learned Counsel for the petitioner has submitted that the matter is infectious. Accordingly, the writ petition is closed without further adjudication. 32.
30.
Yes.
56. This hearing matter.
At 12 o'clock, yes, okay. Kindly inform the petitioner.
Yes.
56 to 12টা বজাত যেটো নেক্সট যেটো মাতিব 12টা বজাৰ পিছত প্ৰথম ইটো মাতি দিম হ্যাঁ এই দুজন দিছে না এজন দিছে হেৰি ফোন কৰক সুধিছিল এজন কি আছে ক'ত দুজন আছে নাই আমাৰ দুজন আছে Yes,
This
sir.
is a matter we
Sorry.
must have argued. We must have argued this matter at least 3-4 times. And before I take your lordship to the papers, may I just give a brief summary that might make things easier for all of us.
Please.
The petitioner before your lordship was serving as a development officer in LIC. And your lordship is aware of the role of a development officer. Basically, the idea is to develop the business. The actual dealings with the clients are done by the agents. And thereafter, once the proposal is taken, it goes to the higher authorities. They see whether the insurance policy is feasible or not. Once it is approved, the policy is issued. The development officer basically plays a very intermediate role. Now, what has happened? He is a highly decorated officer. He was serving in Bongaigaon and he was transferred to Gauhati. In Gauhati, naturally, the volume of business is huge. What happens is there were many deposits taken, but the policies did not get approved for some reason or the other. And the procedure in such cases is that the amount lies with the LIC. It is thereafter, if the policy is rejected, then the amount is supposed to be refunded to the concerned client. Here, what had happened, some policies, some of those kinds of deposits were lying with the LIC. My superior officers tell me that why don't you try and convert these into other policies that will generate revenue? And accordingly, what had happened was some of these rejected policies, amounts lying with the LIC, were adjusted with other policies. Now, that was considered to be an irregularity by the appointing authority. Suddenly, I am issued, show cause notice is issued to me, saying that I have done the entire mischief. They target me now. Now, the superior officers who had actually instructed me to do this, they are not even, nothing is done against them. The agents are, nothing is done. I have singled out.
We may add the word as usual, nothing is done against them. Yes, then?
I have made this scapegoat. These officers say that since there is no monetary embezzlement, and it is an admitted position that these policies have in fact been adjusted against other policies. So you can admit this, we will do the necessary corrections. I accordingly, in respect to the show cause, I admit saying that yes, some irregularities are done. They issue a charge sheet. I'll place all those documents, which themselves show that there is no misappropriation as such. When the charge sheet is issued, even then in my reply, I say that yes, these irregularities are there. Based on that, when the matter is placed before the appointing authority, nothing against the agents, nothing against my superior officer. I am recommended for removal. In the appeal, finally, I take up this entire position that this is what had actually happened. How can I be singled out? They maintain the penalty, and that is how I am before your lordship. May I take your lordship straight to the, first let me show my at page 22. I was issued this certificate of appreciation for outstanding new business achievement, page 22. And that is the kind of reputation I carried in the organization. And suddenly, and before I take your lordship to the show cause, may I just point out the LIC's regulations themselves say, page 23, in the middle, your lordship will find duties and obligations. Your duties as development officer shall be to develop and increase the production of life insurance business in a planned way as far as may be practicable in the area that may be allotted to you or in which you are allowed to work from time to time through the agents placed under your supervision by the corporation. This itself shows that I have to operate through the agents. Then number 2, to guide, supervise and direct the activities of the agents placed under your supervision by the corporation. And if your lordship turns to page 25, 12 subclause 2, okay, subclause 3
Huh.
will show that I cannot have any financial dealings directly with the client. You are strictly forbidden from having any financial dealings with agents or policy holders of the corporation, or place yourself under pecuniary obligations to anyone with whom you are likely to have official dealings as a development officer of the corporation.
Yes.
Now, the show cause notice is in the next page. And the contents themselves will show that there is no misappropriation of funds as such. In view of the complaint lodged by Vinanda Kolita, the policyholder, via letter dated 22/12/2014, as well as the written report of the chief manager so-and-so, via letter dated 9/1/2015, and your subsequent domestic investigation thereof, it has been revealed that you have allegedly committed financial irregularities in various NB adjustments involving block deposits in different names under different agency codes as follows. The check number so-and-so dated 18/8/2012 for so-and-so, 5 lakhs odd, was deposited at GBO 2 as block deposit in the name of Vinanda Kolita by BOC number so-and-so dated so-and-so, and the same was cleared on 25/8/2012. The proposal of B Kolita was declined by the corporation, and the block deposit amount was refunded, but the whole amount was adjusted, refunded against 10 different proposals on different lives who were not at all related to B Kolita under different agency codes. So what had happened was Vinanda Kolita had deposited this amount. This policy was declined, and in respect of this amount, there were other policies that were taken off. So the money, there is no, it is merely an adjustment. There is no loss of money as such to LIC. The similar is the situation in respect of each of these, my lord.
Now, what he had done is he took a check from someone.
I
He
did not.
rejected. No, no.
It could have.
The check came. The money was deposited with the life insurance. Policy did not work out, or
Declined.
even if there was a policy, because some later we have seen, even if there was a policy given to someone, it was either in the name of someone else or something like that happened.
Yeah. So,
But he did not keep the money for himself.
exactly. And the
How
point
he-
is, my lord, one of the most important points is all of this. I am merely a development officer, an intermediary.
Yes.
There has to be a role played by the agents and a role played by the approving. The amount against Vinanda Kolita comes back to the account of LIC. Now, if these are fresh policies are to be issued, it is the approving authority who will approve, because like in the case of Vinanda Kolita, whether to accept the policy or decline the policy is a responsibility of other authorities, not my responsibility. I am only for the purpose of developing business. Now, if your lordship reads the allegation once again, the check number so-and-so dated 18/8/2012 of 5 lakhs odd was deposited at GBO as block deposit in the name of Vinanda Kolita, while BOC number so-and-so dated so-and-so, and the same was cleared on 25/8/2012. So this clearance is in favor of LIC. Now, next sentence. The proposal of Vinanda Kolita was declined by the corporation, and the block deposit amount was to be refunded, but the whole amount was adjusted, refunded against 10 different proposals on different lives who were not at all related to B Kolita. Now, those 5 lakh, let's hypothetically assume 50,000 was policies were taken out in 10 different names, and they are not related to Vinanda Kolita. But I am only a development officer. How can I do it? Now, identical allegations, I'm not troubling your lordship. So what I say is this one, at 26, at page 28.
Page 28.
Page 28 is my short reply. With due regards, I would like to submit my explanation to yours, etc. That, sir, I have gone through the irregularities pointed by your good office, and I admit to have done the same, but under business compulsions. In this connection, let me admit that the amounts lying unutilized in block deposit of the depositors were adjusted against policies on the life of other persons with the verbal consent of the depositors. The act was done with the sole interest of procuring more business under my organization. Moreover, I had also committed to all the depositors, now complainants, of refunding the dues to them at an early date. However, I could not pay them within the committed period due to the financial problems faced by me for a long time owing to ongoing health issues of my ailing father who stays with me and is 89 years old. However, after having learned that a complaint has been lodged at your office by one of the complainants, I had immediately deposited 5 lakhs only in cash, by so-and-so, dated so-and-so, before receipt of your letter to me, dated so-and-so. Now I request your kind self to allow me to refund the balance amount, etc. What has happened? The amount has not been misappropriated. It has been adjusted against 10 different policies. In spite of that, I volunteered to pay 5 lakhs from my own my lord, pocket. Now comes the charge sheet at the next page.
Yes, we are reading. We are reading.
Page 29.
Hmm.
Identical charges. In fact, the first charge is exactly the same. The sentence starting that check number so-and-so of 5 lakhs. And identical charges in respect of
All 1 to 3. Yes.
different policies.
Hmm.
If your lordship so desires, I can read it out.
No, no necessary.
But I would like to take your lordship to page 31 onward. They give the details. Along with the charge sheet, they give the details. In respect of each of these policies against which allegations have been made against me. Now, if your lordship sees the chart, not a single penny is misappropriated. Everything is adjusted, either refunded or adjusted and resulted into policy. Next page also is another chart. Your lordship will find in the remark.
People who are not continuing their policy, this money was adjusted to show as if they continued the policy
in other names.
In other names, but no, some person was not continuing his policy.
No,
this money was available in the pool, so he showed that this.
No, it is not like that. Here, one Mr. X applies for a policy. That policy is declined on various grounds because at the highest level.
Now the money goes into the pool.
Money goes to the LIC account. So from the LIC account, policies were taken out in the names of other people. So page 32 also, your lordship will see the remarks column. All adjusted and resulted into policy. Similar is the situation in page 33.
So this is not a case of defalcation as such or taking away money. It was adjusting money
against other policies.
But the person who had actually paid the money, he was paid back at a later point of time.
Now, here also, my lord, when I submit my reply, that your lordship will find at page 38. May I read this one?
I was reading that.
I am in receipt, etc., etc. At the outset, I do admit the charges leveled against me alleging violation of rules of the corporation. What I admit is that there is a violation of rules of the corporation. Points have been raised on my honesty, integrity, and faithfulness towards corporation in discharging my duties. In this connection, I like to express my views as under. That, sir, I am always committed to the cause of the organization. I am rendering my services with utmost integrity, sincerity, and honesty, and have always tried to hold high the prestige of the organization. I have never done anything detrimental to the interests of the corporation knowingly during my career. My performance will speak the truth. I was the #1 development officer in terms of NB performance under Bongaigaon division for several years. I occupied within 10th position in the zonal list and undivided Gauhati division list. Not a single instance of violation of rules or deviation was pointed out by anybody during my long service period. Sir, after getting transferred from Bongaigaon division to Gauhati division in 2007, I had to face a tough challenge in creating a new agency organization in this competitive scenario. And today, by your blessing, I am running my organization with more than 60 agents. Recently, some irregularities have been pointed out by your good officer. I am extremely sorry regarding declined proposal under BOC number so-and-so. If the amount would have been refunded instantly, the irregularity would have not occurred. I have a good relation with the party and the daughter of the party is my agent. Your lordship will kindly note this. Otherwise, how could I have adjusted against other people? And it has to be done by an agent, not me. I can only.
You were facilitating it.
Exactly. Daughter of the party is my agent. As the amount was lying outstanding for several months, so it is the duty of the LIC to refund. They did not refund, so it was lying there for several months. I was tempted to utilize the amount with verbal consent of the party. I submitted some proposal. If the rule does not permit for acceptance of the proposal, it should have been rejected. But office has accepted the proposals, and I did it for the interest of the corporation and for the interest of the branch. I did not have any ill motive to digest the money for my own interest. A good volume of new business comes through one of the tax consultants. As per discussion with the consultant, some amount were deposited as block deposit under BOC number so-and-so and so-and-so. Never it was told to me that the concerned amounts were against renewal premiums. I submitted proposals with an intention to grow more business. In the month of December and particularly in March, we tried to give our best for procurement of new business. My NB performance during 2012-13 to 13-14 was 1.39 or FPI, etc., etc. Hence, it is crystal clear that we are duty bound and committed to the organization. There may be small variations of rules and maybe one or two cases of procedural lapse. It is my honest confession that I am not aware of many rules and regulations of the corporation. Generally, a development officer submits proposal duly filled and proposals are accepted by the office after thorough underwriting process, both medical and financial. No development officer can force anybody to accept his proposals by breaking rules of the corporation. However, whatever lapse or irregularities are pointed out, I am shouldering all responsibility, and I assure your good self that I will make arrangement to refund all amounts to the concerned policy holders within a short time. I will not allow anybody to defame LIC for my activity. Sir, I am extremely grateful to you for considering my prayer for extension of time for 10 days, etc., etc. It is worthwhile to mention here that the complainant, Mr. B. Kolita, is now desirous to withdraw his complaint. Under the circumstances, I fervently request your honor to consider my case sympathetically and make me free from all charges leveled against me, etc. Now, after that, my lord, the proceedings are held and the inquiry officer submitted a report at page 45.
The records are available. Why not? It has come as a top of the list matter. Why not? We have been hearing for the last 20 to 25 minutes, sir. I've been requested by the court staff not to keep matters at 2, every matter at 2. We start the list at 2 like this. Either someone is not present, we have it at 2. This happens, we have it at 2. This happens, we redo the whole list at 2 o'clock. You are expecting that? If you did not have the records, why did you not tell us? How would you do a disciplinary proceeding matter without the records? Then we are going simply by whatever is available on the petition, on these records. Whatever you have given in the affidavit in opposition and whatever he has given in the petition, unless you deny. If you can have the records brought here during the proceedings, well and good. The proceedings goes on. Before I dictate the order, get the records, good enough. Enough and more. We are trying to dedicate every minute on every case. You tell me at the end of the day that we require the records. Produce it during the proceedings. If it can be done at 2, it can be done during the proceedings. Have PDF copies here. We are not having anything at 2. Yes, whichever way you want. Yes, sir.
All right, inquiry report is at page 45. This is the covering letter. If your lordship kindly turns to page 46, there is absolutely no discussion. Simply the charge sheet is extracted from page 46 onwards. Part 4, till that portion, part 4, the charges are reproduced. Then he says, after reading carefully the charge sheet dated 27/1/2016, I initiated inquiry proceedings with preliminary hearing and regular hearing, etc., etc. And he mentions the dates. Then page 48, part 6, brief summary of the inquiry proceeding. And your lordship will kindly see. Such are the nature of the charges, and this is how he conducts the inquiry. On the first day, preliminary hearing on so-and-so, CSE admitted the charges.
Hmm. That is
My
what,
admission is,
that is the record we want to, without that record,
No,
we will never be coming to.
to the extent of the admission as recorded in the show cause, reply to the show cause
Hmm.
and the reply to the charge sheet, I'm accepting.
Yes.
But I could not have admitted something which is not even my duty. Just to give a hypothetical example, assuming in some case there is an allegation that the petitioner's advocate and the respondent's advocate have colluded,
Hmm.
and the allegation is made against the advocate's clerk,
Hmm. You cannot,
saying that you
you are part of it.
you facilitated. It is something like that.
Hmm. No, that is
I
what,
could not have admitted the acceptance of the new policies
true.
because that is not even within my scope of my work, scope of my job. I could have, at best, the allegation could have been that it was at your instance that this happened. Because the approval of those, taking that Vinanda Kalita example,
Hmm.
one decline policy converted into 10 different policies. That conversion cannot be done by a development officer at all.
No,
That is done at a higher level.
He cannot handle the transfer of accounts.
Exactly. There is an accounts department which,
Somebody else has to be involved.
yes. So now, just to single me out and to entirely proceed on my admission, what could I have admitted? I could have admitted only whatever is within my job profile. So he simply records admission, everything. And your lordship will kindly see.
That is what when we had reached page 49, by the time we were reading the earlier part, we were trying to go through what is the admission. We did not see anything. We need the records to see what is the exact statement recorded on that day. I admit the charges. This is what I have done, therefore the charge is not admitted, but yes, I made a mistake. Something. He must have said something.
The admission is, as I said, it is to the extent of the reply.
Hmm.
Now your lordship will see each of the charges. I am not troubling your lordship. Each of the charges, he records that I have accepted the charges, therefore guilty. Therefore, charges are established. And nothing, very cryptic. There is no finding, there is no discussion.
How many days did the inquiry run? Single day.
Those dates are mentioned.
Preliminary, regular, and preliminary hearing on 7/6, regular and final hearing on 14/6. 1 day.
One. And the fact that what is the role of which officer, what is the extent of my culpability, what is the extent of my role, nothing is discussed, man. I am simply singled out, made a scapegoat and penalized.
This P9. PA reply by CSC to the explanation letter. Reply by CSC to the charge sheet. They are made part of the inquiry. The inquiry starts after the reply to the charge sheet is not accepted. And they take it as an admission. From this, it appears that they have not even taken your statement.
Nothing is there.
What they have said is, PO submitted documents so-and-so to prove the charge. CSC did not submit any defense. I hold the charge proved against established. Now, on the same day, he is required to prove his defense.
And I am.
Where are the witnesses?
They mention a few witnesses.
Where?
Yeah, lordship will kindly see. Just some documents. There are no witnesses at all.
No. Any document which is produced has to be
proved
by the witness.
Yes,
and the contents.
And there are no witnesses. And the biggest, that is why I say that this was merely the senior officers realized that they are going to be in a serious problem.
To our understanding of what we have done, we have been taught is, if you believe the admission of the person concerned, you don't need to produce anything. He has admitted everything to the charge sheet. What do I inquire into? Please do whatever you want to do. It goes back. The moment the inquiry is held, that means you do not believe that admission. The moment you do not believe it as a neutral Inquiry officer, you need the documents to be proved, the witnesses to be cross-examined. Because you do not believe it, that is why you continue the inquiry.
Your lordship has hit the nail on its head, because had the admission been sufficient,
It would have gone back simply on that.
there was no necessity of an inquiry at all. It was only because the appointing authority felt that an inquiry is necessary, which means you have to inquire and prove the charges.
Justice Bhuyan's judgment. There was an admission of guilt, then the inquiry was proceeded with. No, this is Roy's judgment. That once you proceed, that admission goes. Now proof. Had you sent it back at that stage itself,
Yes,
finished.
Absolutely. That is the whole case.
There would be no writ petition pending. Admission of guilt proceeded on that. But once you say, no, I will bring on documents, that is
prove.
when you disbelieved that admission.
And the other thing is, they very well realized, my lord, that a mere admission would not be sufficient, because he could not have admitted for the new policies being issued. A development officer, it is not his job to do that. It is the job of various higher level authorities in LIC. Basically, they wanted a scapegoat, and the documents speak for themselves.
Then there is a
And
show cause.
show cause notice, they not only, my lord, your lordship will kindly see the penalty proposed at page 54.
Just a minute. How does he say so? I differ with the findings of the inquiry officer and hold the CSE guilty of all the charges as enumerated. He is
Last two, because
No,
he has said not established.
no, he has held it to be guilty.
And your
It
lordship,
is not that it, in my opinion, all the charges stand proved.
that is one aspect. And the other aspect is proposed penalty, your lordship will see. He has imposed on me a financial liability of 21 lakhs. There is no misappropriation. Where is the scope for recovering 21 lakhs from them? It was an absolute farce, my lord, absolute sham. Basically, they wanted a shoulder to fire.
While giving you the inquiry report, the moment he says that I propose this penalty on you, has he not made up his mind that you are guilty?
Yes.
Then why the inquiry?
And that is why he says hell.
Then why the inquiry report?
Inquiry
Why is
report,
it given to you?
no, inquiry report now, after the ECIL.
Not that. I'm on the intent. I have
Intent,
held you guilty.
Yes. Yes.
Why give it to you? You held me guilty, punish me. So I want to punish you like this. I am holding you guilty. So this is the inquiry report. Tell me what you have to. Can he do that?
And on top of it, that 21 lakhs. There's admitted possession. The documents say that there is no misappropriation. And against this, my lord, when finally I realized that I have been made a complete fool in this whole process, this is when I replied to this show cause, proposing to impose penalty, I replied.
Just one more thing on the inquiry part. When you admitted the charges, were you told the consequences thereof?
No.
Is it not necessary to explain that this is the consequence of what you are admitting? You will be held guilty and you would be liable to punishment.
At that stage, my lord, I was acting I was totally
No.
caught off guard.
The person before whom you admitted guilt, if the reply to the show cause notice was an admission of guilt, it stops there. There is no inquiry thereafter. If the reply is not satisfactory, or if they feel that the plea of guilt is not enough, then they go ahead to hold the inquiry. During the inquiry, when you say that I plead guilty, is it not the role of a neutral person to say, sir, you are admitting guilty, I'll say you are guilty and you may be penalized?
Yes. That would be necessary because without knowing the consequences.
That is not there in the inquiry
No,
report. We
no.
don't find it in the inquiry report. You see why we need the disciplinary proceedings. What happened is what we not to know. We'll continue as long as we can. We'll continue as long as we can. No, sir. Huh? You have to? To do what? Physically to do what?
But in that
They
case,
want advocates to go to the office and take the records. That is
Sorry,
fixed.
repeatedly I'm saying sorry. Because it is my camera.
Oh, it is there in the chamber.
in that case, my lord, may I suggest this?
Will
Since
we
he is
get it?
expressing.
If it
genuine-
is with you, if it is with you, it's okay.
In that case, my lord, may I suggest this?
Yes. Let us
Your
finish
lordship will keep it as part heard.
Ah.
We can continue next Thursday and finish off the whole matter.
Till next Thursday, I do not know pressure level to success.
Because I am almost nearing my completion.
Next Thursday to kiman ase? Next Thursday would be 19. 27 already fixed. Okay. Let us see, Mr. Chaudhary, if possible, how much we can go through. And on the next date, maybe any date will.
Otherwise, I
can
can
be done.
conclude also. My part.
If you conclude your part, all we need to have is arguments
Mal-
today
mal-
and a production of the records to substantiate his argument.
Mal.
Otherwise, you know what is playing in the mind of the court.
Only after my conclusion.
Okay.
Half an hour I will.
Now, my lord, I was on page 55. My
Yes.
reply to the show cause on the proposed penalty.
Hmm.
Now, for the first time, I realize that I have been made a complete fool in the process. And this is what I say, my lord. I am in receipt of your show cause notice dated 31/3/2017 and noted the contents therein. In this regard, I would like to inform you that I have already communicated to the inquiry officer by my submission dated so and so regarding my willingness to refund the entire amount with interest, although he was not required to. But, sir, for last 4 or 5 months, I am running after my father's illness. My father is suffering from eye cancer and he was in ICU for more than 2 months. His condition is not good. I have to spend a huge amount for treatment of my father. Under this circumstance, I request your honor to allow me to deposit the amount so and so in 3 months. This was again totally wrong advice, my lord, but in any case. Sir, I do agree that I have made some procedural mistakes due to over enthusiasm towards my organization LIC. In fact, the proceedings before the inquiry officer clearly reveals that such mistake cannot be solely attributable to the undersigned. Despite the above, as a good gesture, I had admitted the charges and expressed my willingness to refund the money. That as regards the proposed penalty of removal from service, I would like to submit that had I been aware of such action, I would not have admitted the charges. Exactly what your lordship has said. Since apparently such mistake cannot be solely attributable to me. Additionally, since there is disagreement with the findings of the inquiry officer under the law, I am entitled to know the specific reason for such disagreement as well as for de novo inquiry.
Yeah.
However, while reposing confidence on your good self, I would like to request that such proposed action may not be taken against me, else at this age of life, it would be extremely difficult for me to survive with my family and old ailing parents. In this aspect, while taking a decision, my previous unblemished service career may also be taken into consideration. More so, removal from service is a major penalty, carrying both personal and social stigma, etc. Now, my lord, the appointing of authority, finally, again, I am not troubling your lordship, it's a very long order. Entire thing proceeds on admission, and page 62, he maintains that 21 lakhs recovery. Last para. Now, therefore, I, the disciplinary authority, order that the penalties of recovery of 21 lakhs, etc., and removal from service, which shall not be a disqualification for future employment, be and are hereby imposed.
This is a page 62.
62.
This was the appellate order.
Appeal, I did not go. In fact, that is one of the objections. They have taken technical objection.
Violated, or if it's an unreasonable order, I don't think appeal is.
And
necessary.
the other problem is, my lord, once this happened, once this final show cause notice came, I realized that all the superiors have ganged up together against me. There is no point filing an appeal. Now, my lord, so far as my submissions are concerned, I'll just give the bullet points. I won't make it too long.
Hmm.
First submission is, my job profile itself is that of an intermediary. So, the admission that they are talking about
Hmm.
has to be confined to my role as an intermediary. The conversion to different policies in different names, that obviously cannot be attributable to me. That is done at a much higher level.
Hmm.
So you are making allegations which cannot even be attributed to me. It's like the director of social welfare being asked to show cause why the bridge on some has collapsed.
Hmm.
It is totally unheard of.
What do you say about this page 58,
Mal.
the second paragraph? Whereas in his reply, did not, do we have page 58?
Did not admit, yes.
Did not admit all the charges unconditionally. The inquiry report says, based on those two documents, he has admitted it.
Admit.
Then this same discipline authority comes to a conclusion that because of that admission, inquiry is correct and therefore I hold you guilty.
And here he is
This
recording
is
that.
what we were asking. The moment you say that it is not unconditionally admitted, you have to do the full-fledged inquiry.
Exactly.
You cannot act on the alleged admission, which was
The sequence
not
of
complete.
the procedure is like this, Malik. If a show cause notice is issued and the delinquent employee says that I admit to all the charges,
Nothing more to do.
nothing more
The
to do.
penalty.
Now, the fact that they proceeded on to hold an inquiry, they have to prove the charges.
The admission is
And at least the extent of my liability has to be established.
which would require the presenting officer to exhibit the documents, the persons to give statements on those documents. Mr. Kolita and other persons coming and saying, yes, we made a complaint. He cross-examines.
On top of it, he has to establish,
Yes.
the inquiry officer has to finally arrive at a conclusion that I was the one who physically and personally converted.
And if it was a case where you had arranged or facilitated, who else were involved? How did it happen? There should have been a suggestion for a further inquiry so that the actual truth comes out.
And if it is only facilitation, it cannot entail a major penalty.
Cannot.
If my role is only to the extent of facilitation, it cannot invite a major penalty. It can at best be a censure or a warning or something like that. So maybe withholding of one increment.
Even something major, withholding of increment, reduction of whatever. But to take away food from the table when you facilitated and others actually participated.
And actually implemented, executed. Otherwise, my lord, if I have been able to satisfy your lordship to this extent, I won't even go any further because this is the whole case. They wanted a scapegoat, found a wonderful scapegoat right in front of their eyes, and they proceeded.
If the inquiry proceeding goes because of whatever has been discussed, then the penalty order automatically goes. Now we have to see whether they are required to proceed with those charges to prove them.
Now, my lord, he has already crossed his retirement age.
As they would have, as would have done. Now, what happened to the money? Have all the people got back the money?
They must have by now.
The person, the
Because I was.
There is a stay. There is a stay.
There's a stay. Stay of what?
Or disciplinary proceeding or recovered.
On the recovery, there is a stay.
You have not recovered from him. Why should it be recovered when the money was already with the LIC? What was to be recovered by him? That is why the stay, sir. You have to show us from the documents that the money was not with you as per the charge sheet. If policies have been issued to certain persons who were did not pay for the policy. That is what he did. He took Mr. Chaudhary's money. He created a policy for you. That is your allegation. From the bulk money he took and he created 10 more policies. When this money should have gone back to Mr. Chaudhary. Now this money is with those fake policy holders. Let us say fake.
They are
because
not, they are
No,
not
no.
even saying fake.
No. What I'm saying is that those are persons who should not have had a policy,
Exactly.
but are holding a policy, so we'll use the term fake. Now, those persons who got that policy, that money is with you, the policy is with them, is it not? But since it was a money which they had not paid to you, all could have been collected and returned to Mr. Chaudhary. Why should you take it from him and give it to Mr. Chaudhary and you return the money?
Charge he has admitted and.
So, the money is with you.
Can be-
Recovery of what?
Can be appeal the record.
Ah.
Again.
We'll come back.
Let's-
Let him finish. We'll come back. Definitely we'll come back.
Now, my lord, this goes absolutely to the root of the matter. So, looked at from any angle, my lord, firstly, I cannot be charged with and found guilty of something which is not even attributable to me.
Mm.
Secondly, at best, my admission would have been confined to facilitating. The second question that would have to be answered is whether facilitating all these transactions can invite as drastic a penalty as removal and recovery of 21 lakh. Now, the third aspect is, my lord, your lordship will find in the order imposing penalty, if your lordship will have the LIC's regulations for a moment. দেখুন।
Yes.
The manner of imposing penalties is clause 39, my lord, that your lordship will find at page 24. What it says is this: without prejudice to the provisions of other regulations, any one or more of the following penalties for good and sufficient reasons. Your lordship will just mark this one: for good and sufficient reasons, and as hereinafter provided, be imposed by the disciplinary authority specified in Schedule 1 on an employee who commits a breach of regulations of the corporation, or who display negligence, inefficiency, or indolence, or who knowingly does anything detrimental to the interests of the corporation or conflicting with the instructions, or who commits a breach of discipline or is guilty of any other act prejudicial to good conduct. Now, what are the penalties prescribed? A is censure, B is withholding of one or more increments either permanently or for a specified period. C is recovery from pay or such other amount as may be due to him of the whole or part of any pecuniary loss caused to the corporation. This is not even that 21 lakh goes.
That is what we
straight-
are asking. That is what we are
straight
asking. What
to-
is the pecuniary loss?
Exactly. Now, next, reduction to a lower service or post, or to a lower time scale, or to a lower stage in a time scale. Next is compulsory retirement. Thereafter is removal. Thereafter is dismissal. Now, what it says is, for good and sufficient reasons to be, which have to be recorded, obviously. Now, if your lordship comes to the order imposing penalty, there is not even a discussion regarding the
Why that penalty?
why the penalty. If your lordship comes to the order at page 58, he discusses all about the inquiry proceedings, etc. Goes on till 61, and out of the blue, without even discussing the provisions of clause 39, not even a discussion. Now, therefore, I, the disciplinary authority, order the penalties of recovery of so-and-so and removal from service, which shall not be a disqualification for future employment, so-and-so, in terms of regulation 39(1)(c) and 39(1)(f). Why not 39(1)(a)? Why not B? There is absolutely no discussion whatsoever. And this mandate that it can be done for good and sufficient reasons, he does not even comply with that.
This man, he does not know, apparently. Page 58, when we had read earlier, Whereas Mr. So-and-so did not admit all the charge unconditionally. Kindly came to page 61. What
Yes.
he says.
Here he records
One,
something to the
two,
contrary.
3, 4, 5, 6, seventh line from the top dated 31/3/017. If you find that line.
Yes, further admission.
Further admission of charges on record by the CSE in the case cannot be claimed as as conditional. Same man is writing both the pages.
But as I said, brother, this was just to make us show that they have done an inquiry. Nothing else. There are some things done genuinely and there are some things done for public consumption. This is one, like how the politicians do it. Public consumption. And I can assure your lordship, my lord, even in the last round of arguments that we had, the only argument is that admission. That is the only argument. Nothing else. If it was a case of admission, there was no need for the inquiry at all. So how can they contradict themselves?
Kindly ask him if he can trace out the judgment.
Oh,
If the proceeding goes on, then admission of guilt goes.
yes.
Then you have to rely totally on the proceeding.
In fact, my lord,
It is a matter of the what we were very familiar with the CRPF, where they held a proceeding, guilty, and then the charges were sought to be proved by the proceeding. Writ petition, they said that guilty is, he had admitted his guilt. That is when this court said no. The moment you say inquiry officer, presenting officer, that admission of guilt goes. Or if the admission of guilt was there before the inquiry officer, it was supposed to be shut down there. You could not have gone. Since you went ahead, admission goes. Now let us talk about the proceeding. That is when I can enter into the proceeding.
This pertains to CRPF. Huh? I'll check it
CRPF,
up.
Justice Roy or Justice Boone.
I'll check it up. And in fact, my lord, for your lordship's convenience, I have prepared a short written argument so that it becomes convenient for your lordship. What is it? Giving the chronology of facts and the submissions in very brief, my lord. Good. I have just given the facts and my submissions, just the bullet points one. I wanted to refer to a few judgments, but I don't think it is necessary.
Is it the same ones which you have referred in your submissions?
Yes.
Yeah, I'll go through it.
Basically, in case they are able to establish a case, only then these submissions will come in. Additionally, as an alternative argument, I had made the submissions regarding disproportionate punishment and all. Perhaps all that will
only if we find that the punishment was liable to be.
Exactly. Those issues will come only then.
Okay.
So subject to
page 28, sir. Yes.
Sir, the picture of this proportional right. Page 28. With due regard, I'd like to submit my explanation. I have gone through the irregularities pointed out here and I admit I have done the same. But under business compulsion condition, let me admit that the amounts lying unusually in the plot were adjusted against policies on the life of persons with verbal consent of position. The act was done with the sole interest to procure more business under my organization. Moreover, I had also committed all the depositors now complainant of refunding their dues from the earlier. However, I could not pay them within the committed period due to the financial loss faced by me for a long time, owing to the ongoing problem. To stays with me, leaving thereby he has consumed for his personal order.
Sorry?
He has admitted that he has due to fear faced by me for a long time, owing to the ongoing health problems of my ailing father who stays there with me and this. Now he is saying, last paragraph, I request to allow me to refund the balance with a further request to give me time up to the month of November 2015, only to arrange the funds to repay the same. Till date, that is nothing.
Now, just tell us one thing.
Minor.
Is it not the case of the disciplinary authority?
that part,
Okay.
lost it, I learned.
But may I come back in 5 minutes?
Please, please.
Then charge sheet is, I am not reading. Charge sheet is that charges are that you also engage in deposit of sum and data also because the charges, that your lordship is the charges. Possibly your person, you have failed to maintain absolute liquidity.
Yeah.
Here. Then during the proceeding, his statement regarding the charge sheet, page 39. Lordship is read and again. Page 38. Here, at the outset, I admit the charge. He has admitted unconditionally.
Yes.
He has admitted the charges unconditionally.
Where? Page
Page 38.
38. Yes.
I am in receipt of your letter dated along with the subject dated 27/1/2016, and I have noted that sometimes there, and I also received of your letter at the outset. I do admit the charge relatively. My allegation violation of the rules of the corporation.
Now, what is he admitted? I admit
I
that.
admit that the charges levied against me alleging violation of the rules of the corporation.
Now, let us stop here for a moment. What
Points
is
have
it?
been-
No.
Points have been raised on my NSC integrity and further corporation is saying my I like to express my view. He is explaining. He is explaining, and then I'm coming to last page of page 39. Bottom page. Bottom page. Again, he is saying that I will refund the money. However, whatever lapsation or irregularities I have pointed out, I am shouldering all responsibility. I assure you to say that I will make arrangement refund all amounts to the concerned policy holder. In short time, I will not allow anybody to defend LIC my activity, pay my LIC. He again committed that he will refund. Then my lord, page 40. I am extremely grateful to you considering my prayer for extension of time days. If you want to mention that complainant of Mr. B. is now dangerous to withdraw this complaint now, but he has admitted that he has admitted and he assured that he will return the I request you submit the written brief, then he presenting officer brief I read. Page 43.
That was for something for the inquiry officer to have appreciated.
Yes. Then
Should we appreciate it? Should we?
During the inquiry, he admitted.
According to the presenting officer, he admitted.
Yes.
So that is like telling us to go through the arguments made by the prosecuting counsel during a trial. Should we go into that? What was argued?
My humble submission is
Presenting officer's brief is his arguments to the inquiry officer. We are to see whether the inquiry officer had correctly done or not. We are not to see what the presenting officer had made an argument. So we do not want to go into that. Reading that will only be a waste of time. How it was appreciated by the inquiry officer is what you can show us.
Then my lord, the defendants remain physically present, inquiry repeated the preliminary hearing.
What are you reading, sir?
Repeated all the charge.
What are you reading, sir?
But page 39.
What is page 39?
Page 40.
Page 43 is what?
Bottom.
Bottom.
What happened in the preliminary on 7.
Page 43. Again, you are reading us that presenting officer's brief. Why, sir?
Just to appreciate that what is the record. Next chart.
No.
We are.
Yes.
Then regular hearing done. Then my lord, inquiry report 27/2006. Inquiry report. Proceeding under explanation. Charge sheet is subsequently by that the check number so and so, the para part 3. I depend below the charges contained in the charge sheet. Charge containing charge sheet, that is the part 4. Then charge memo, charge sheet. Then charge wise findings. Page 49.
Yes.
In consideration of the documentary evidence produced by the presenting side or an argument put by PO in the written, I give below my findings in respect of the charge, each charge separate. Charge mentioned in para 2 charge so and so, 2016. PO submitted document number PNP to elected to prove the charges. CSC did not submit any defense document and or witness to defend the charge. Then my findings, taking the document submitted with PO into consideration, I hold the charges mentioned the charges against the asset. Then charge mentioned in para 3, charge. At both the charges, CSC did not admit the defense document and witness that defend the charges. My indicating the document sufficient to consider it.
Kindly tell us who exhibited P1, P2, P3, P4, P8, P8, P9, and P10. Prosecuting who? Presenting officer exhibited them. And who testified the correctness of those documents? Who testified the correctness of those documents in the inquiry?
In his presence, sir.
In his presence, let us listen to us. Ask. If you answer my question,
Sir.
we are with you.
Sir.
If you refuse to answer us, we will let you say what you have to say. Silently, we will have an understanding. We will reflect it. Would you like this court to understand what you are trying to convey? So kindly tell us. There is a document P1. P1 is what? You have given a list. What is P1? P1 is complaint dated so-and-so by Binondo Kolita. Am I correct? Now this complaint that it was actually given by the Binondo Kolita. Binondo Kolita wanted it to be intended that way. Was Binondo Kolita called for and asked, or was it exhibited, or was it proved the contents of that particular document by Mr. Binondo Kolita is what we want to know. Yes or no?
Not inquiry report, not a transfer.
Not there. Now, if you see, you are talking of P2. It is again another complaint by Binondo Kolita. Then if you have P3, what do you have? Bank statement of Binondo Kolita.
Yes.
Is it not? Now, Binondo Kolita is not there in the inquiry. You are showing a document of Binondo Kolita. Binondo Kolita makes a complaint. Is it not? You're trying to prove a charge. The charge is Binondo Kolita had to make a complaint against you. Binondo Kolita is not there. When the complainant is not in the inquiry, and there is a submission in his reply, Binondo Kolita wants to withdraw the complaint, sir. Is it not? Was it not necessary for Binondo Kolita to have been there? In his absence, is the complaint. Does the complaint have any value? It is not a court order that you don't need to prove it. It is not a certified copy of an official document that you don't need to prove it.
Yes, sir.
What is it? It is a complaint allegedly made by Binondo Kolita. Now, step out of the LIC role for a moment. Step into the shoes of an inquiry officer who's impartial, neutral. Someone stands up to you and says, look, sir, this man has complained against this man. What would you first say? Bring the person complaint who made a complaint before me. I have to know whether it is a correct complaint or not. Basics. Is it not? In the presence of the delinquent officer or in his absence, inquiry officer has to see that the thing is proved. And therefore, we were trying to inquire of him. Don't show us what the presenting officer has done. It is valueless for us. We will see what the inquiry officer has done. Did he act impartially? Now, the disciplinary authority says, tell me why I should not punish you. He says, okay, these are the reasons. Disciplinary authority feels, no, we need to prove it against you. When does proof come in? When you don't believe the admission. Is it not? If you believe some man is guilty, will you try to prove it again? Is it not? Or you bring in more evidence to prove that no, he's guilty, we'll have to prove it. You don't need to. Admission, guilt, finished. You decide to proceed in the inquiry. You don't bring in one single witness. Not one. The presenting officer is there, the inquiry officer is there, he's sitting there, and he's sitting there, he's the charge officer. Inquiry officer says, he has admitted in the written statement. Therefore, I hold it proof. That could have been done by the disciplinary authority himself. Why need an inquiry officer? He has admitted in the written statement, is it not? In the penalty order, the disciplinary authority says, because he did not admit anything, I had to hold the inquiry. I had to order the inquiry. That means the admission part is gone. Now we have to stick to the proof part. Preponderance of probability. One sentence against the delinquent, we will not try and decide why. that decision was taken, that assumption was made. It is preponderance of probability. Two ways, you decide, I don't interfere. But when the document, the complaint is not proved, when the document which shows that the money went from here to there, signed by someone else than the accused, has gone from the coffers of the LIC or from the policy of one person to the policy of another person, he is not a signing authority. Who did it? Would not a neutral man ask? Who signed that document? Where did you get the check from? Who allowed the transfer of money? He facilitated. Please transfer the money. That fellow says, yes, I will transfer the money. Did he transfer? No. Transfers was done by someone else. Where are they? There is again a judgment of the division bench of this High Court. If there is a possibility that many are involved, holding it against one, the inquiry proceedings go.
Here my submission is that way.
Yes.
Here my submission is that.
Ah.
He did not call any defense. That is,
Did you call any prosecution?
it is the document production, he never objected the document.
Should he?
Because it's the disciplinary proceeding, the preponderance and probability.
Oh.
He did not.
Okay.
He did not, that is, that did not say that I need to agree with this. Presence of the inquiry officer and presence. There is no objection on the side of the charge officer. These are wrong. My submission is that. Then my charge, clear submitted, so charge submitted it, then CSC, my finding, though CSC is accepting charges in general term by the union, so his decision statement so and so do not categorically accept the charges with the charge stated so and so, which is you are also arranged to propose it so and so to block and put the document so and so, even to establish that it were adjusted under different proposal policies on different types and different agencies. Right?
Who adjusted it?
Because the
No, who adjusted it? Who adjusted? Could he sign? Could he sign anything? Your duties of your roster of duties doesn't say so. Don't deal in finances, what they say.
Develop the duties.
Show us. We'd like to see. He has showed us it is not the duty.
Charges is mentioned adjusted under the different proposal.
He has shown us it is not the duty at page 23. He cannot deal with policies. That is what Mr. Chaudhary has shown us. Show us to the contrary.
Well, he has himself here is speaking. He himself at the reply of the shoppers he has stated.
A man stands up to admit his guilt of a thing which he probably could not have done, was not part of his duty. Is it?
He has himself stated that I have arranged.
Yes.
Page 28. Then, my lord, the findings of the charge officer, those CSC has accepted the charges in general term and the not categorically under the charges mentioned charges so and so deposited the document under so and so right. Therefore, I hold the charges mentioned paragraph CSC partly accept. Then, my lord, the suppose notice was issued. Then, for the position of the penalties, lordship has gone through that reasonable opportunity. That's the page 15. After careful considering inquiry report dated 21/7/15, along with the reports of the case and the minutes of the proceeding and submission of the CSP by letter, I find that it was given the CSP, defend himself in the charges level against him, and the principle of evidence complied with during the inquiry proceeding. On the basis of evidence taken on record, minutes of the inquiry proceeding, the facts of the circumstances, the submission of the CSP and repeating the charges, and agreeing to refund the entire amount with interest unaccountable confidentially. I defer the financial character as held that he is guilty of all the charges and mentioned the charges as the establishment involvement, state charge starship. The insurance of so against the inquiry report, my lord, the charge officer has a representation of the charge. Charge officer a representation. That representation against the inquiry report.
Oh, that's for us.
What are we?
I'm sorry to interrupt. There is one categorical assertion that I forgot to show this during the course of my arguments. If your lordship will kindly take up page 8 of the writ petition for a moment.
Just give us 1 minute. Just 1 minute, sir. P10, lecture 1, lecture 5. Just 1 minute. Mhm. Sir, can I just ask him one more thing? Uh, please, look,
No representation against the.
please listen to us.
Incorrect. No.
Please listen to us. While differing with the findings of the inquiry officer, page 4 and page 5 of the charge sheet had been referred. Is it? I differ with the findings of the inquiry officer and held the CSE guilty of all charges as remunerated in the charge sheet as the various exhibits such as P10. Now P10, if we look in the inquiry, it is annexure 1 to annexure 5.
Page of the page 44.
These are tables.
Page 44.
These are tables.
Page 44, 10.
These are tables signed by the
Showing the.
signed by the
That's it.
signed by the at the below signed by
Senior division.
and the penalty order has been imposed by. So to prove document annexure A1 to A5, you would require the senior division manager to say that yes, this is the correct calculation. So witness in the proceedings has now passed the impugned order. Instant. If you want to prove annexure 1 to annexure 5, it is signed by whom? The senior divisional officer, is it not?
The lecture, my lord, will be part of the.
Charge sheet. It is part of the charge sheet. Let us assure you. One
Your
page
lordship,
before.
kindly tell that.
Ha.
27/1/2016.
What?
Charge sheet date.
Ha.
Then he signed it 27 charge sheet date.
Exactly. He has signed this calculation also.
Documents he
The
has signed.
calculation is signed by him, is made by him, made by whom? Who has made this calculation?
These are the major document on the.
No,
same
who
date.
has made the
The
calculation?
Date of charge sheet, how will sign the on the calculation?
All right. Senior divisional manager has not signed it as a calculation.
No.
He has signed it because it is a part of the charge. Someone has made this calculation and the senior divisional manager, while imposing the penalty, says that I am relying upon those pages to hold it to be proved, that calculation to be proved. Is it not? Page 53, third paragraph, he says that I am depending on these pages.
Yes.
Now, these pages is not signed by, is not made by the senior divisional manager.
No,
This
calculation he has not.
So someone had to prove the calculation. It is correct.
He has.
Before he can depend upon it, someone has to prove, yes, this is the correct calculation because this check number is correct, the premium amount is correct, the allotted amount is correct, the agency code is correct. Someone has to say. When during the inquiry was it done? There is no witness. Who proved the calculation for the senior divisional manager to hold that I will rely on that? If the senior divisional manager has signed it on this side, immediately before the table, was it not necessary in the inquiry proceedings to say it is not because of the calculation? I have signed it as a part of the charge sheet.
But on the same.
Could be. But this is the calculation. Someone proves the calculation or senior divisional manager says, I have made the calculation. If senior divisional manager has made the calculation, he is the witness.
He did not.
He has to be the,
That I made the case.
suppose there are only two positions. It is not his calculation or it is his calculation. There are two possibilities.
Because on the same date he signed.
Yes. So it is not his calculation.
It's not.
Who proved it? Who proved the calculation for him to come to a conclusion? Someone has to say the check number is correct, policy number is correct. Who said? To the inquiry officer, who said it? Nobody.
And the CA also admitted also.
See, admitted what?
This is
You don't, you,
the responsibility.
that is the whole problem. The answer that we need from you, you are answering before you hear us. You are presuming that we are on some particular mind. We are not that. We are trying to get an answer from you. The inquiry of you, when he says the admission, what does he admit? Kindly have come to the admission again. What does he admit in the written statement? What does he say? We will read it together. At the outset, I admit the charges leveled against me alleging violation of the rules of corporation. So I have violated the rules of the corporation. I agree. Points have been raised on my honesty, integrity, faithfulness. In this connection, I express my views as under. So therefore, that particular admit does not contain what he has said thereafter. It is not a complete admission, rightly held by the disciplinary authority when he started the inquiry proceedings. Why at the end of the day go and say that you have completed it, completely admitted? How can you do that? How can you do that?
Before the
Where is that?
that record is.
Ah,
That record is.
because the inquiry officer does not say that you have admitted during the inquiry. Inquiry of, now come back. We don't need the records actually. We'll just be giving you time for nothing. Please come.
That other aspect is that
Kindly
there
show
is-
us.
There is no representation against the.
No. Charge-wise finding. Kindly show us. Where is the writing that he has admitted during the inquiry? Kindly show us. CSE did not submit any defense document. It is not said that CSE has admitted. Next, point number 2, CSE did not submit defense, but it does not say CSE has admitted. Taking the document submitted by PO into consideration, I hold the charge established. It is not only admission of the CSE. Show us one document, one sentence here that yes, before the inquiry officer, he has admitted. I think the rest of the submissions should come after you have the
That
records.
says,
Okay.
and the CSE by the submission dated 14/6 and the date.
Now, 14.6.
Has
Let
accepted the charges.
you
that
keep
are-
on reading. When we are asking a question, you simply keep on reading, avoiding our question. When is 14.6? Prior to the charge sheet. Charge sheet is signed on 21.6. How could you depend on 14.6?
13/8.
13.8. Where is the 13.8? Show us 13.8 is reply. Now come to that. Where is 13.8? Where is 13.8? Where did you find that word 13.8? Where did you find 13.8? Established 27.1, 27.1. Where did you find 13.8, sir? You just said 13.8?
I
Cannot be 13.8 because the inquiry report itself is 20,
completes on 27.1 or
21.7.
21.7. How can there be something on 13.8?
13/8/2016.
Eh?
13/8/2016.
Where is it? Show us.
It is not in the.
Cannot be, my lord. The inquiry report itself is 21.7.
13.8 is, I will tell you what is 13.8. 13.8 is the first reply, probably. Hmm. 13.8.16. How can there be an admission when the charge sheet is of 21.6 or 27.1/2016? An inquiry completed in what? 21/7,
21/7. How can?
2016. How can something be of the delinquent officer be there on 31 or 13/8?
That's my HTTP drive. Because some of the, another part of the admission letter.
Eh?
Other admission letters I have in my affidavit.
Were they made part of the inquiry? Whether they are made part of the inquiry proceedings? 7th of April, 15. We are closing it up very soon, huh? We have little time.
And I show some judgment.
This is item 1.
And I-
We have item 59, if I'm not wrong. 59,
some judgment-
56.
some judgment I have.
Eh?
Judgment.
Flegma can give it to us. Yes.
One written agreement I have already submitted.
But April. Look, 7th April is not a part of the inquiry proceedings. Your inquiry proceedings first complaint comes in 2015. Reply by CSC dated 26 and reply by CSC dated 24. From where you are bringing, these are not even part of the inquiry proceedings. We have to look into the inquiry part of it. Otherwise, he will come up with documents now which were not in the inquiry to say, look, sir, this is the man writing and given to me, sir, this is the man. He asked me to do this. Can we take into consideration?
Representation.
And against the inquiry report?
Denying the inquiry.
Huh. When the inquiry report says that I hold you guilty, what will you say? Once the inquiry report says I am holding you guilty and I will hold it against him. He did not reply to the inquiry report, we'll hold it against him. No, we'll hold it against him that he did not reply to the inquiry report.
I did.
Even then, you have to substantiate your inquiry, sir. You are in the lead court.
I have replied also.
My
It is.
submission, my submission is the charges are admitted,
Okay,
inquiry was conducted,
okay.
and on the basis of the admission of the charges,
Hmm.
the penalty was imposed.
Okay.
And he has categorically stated again and again that
Okay. What are the judgments you want to rely upon? Huh? Unfortunately, I was not there. You will have to give me again.
My written agreement is there in the record and along with the document. It was hard in land and it was kept a CAV.
Hearing you, this big bunch.
One bunch melody is along with the judgment also.
Huh?
Now,
Sir,
my
দেখো
letter
এরকম
is
এখন
from judgment.
দেখুন হয়
Breach of contract, breach of confidence.
এখন ঠিক আছে কোনখন তেওঁ খাব খুঁজে সুধি লওক গোটেইখিনি দিব তেওঁ কিন্তু তেওঁ দিব ন আপুনি বিচাৰিব নহয় এনেকুৱা লিখিব Yes, sir. Which are your documents kindly point out?
This is my written agreement.
And
Yeah, my letter, I have told the judgment.
okay.
Like my-
What are the rest of them? Rest of them not given by you.
These judgments I have given. Four judgment I have enforced.
Some I must have given.
Well, at the judgment,
Which are you reading? Additional District Magistrate, 1996.
Yes.
In fact, on account of the clear admission contained in the writing given to the sentence, the charge against the question given to consider for the nature of the punishment. This is what we are trying to say again and again. Once the charge is taken to be admitted, the only thing that remains is to punish him. Where does the inquiry come from?
my letter para four.
I'm reading para 4, the highlighted portion. I'm reading
Having
exactly that.
considered- Having, he has replied. Supreme Court. Having considered the rival subjects and also having gone for the written statement filed, I find that the High Court cannot be successful so far as non-supply of the inquiry to the court is concerned, procedure violation. It is kept on the sub-contention was built in the extent. High Court court has noted to the respect nothing could be pointed out as the learned counsel for the respondent controversy in the High Court. It or not even Reliance placed on the written submission being so also is of the respondent one. The state decision cannot support the contention tempered with that even if there is no grievance made in the expedition of the High Court, bound to consider the state. So far as the grievance about the non-examination witnesses and non-supply of the document is concerned, in our view, High Court has clearly been ignoring the salient feature of the case, namely, respondent himself has statement that prohibited, we have received an amount of so and all, which would not be deposited by him, along with his associate on account of careless and fault. It is difficult appropriate how the statement could be said to have been brought about by coercion and tried to be submitted by the employer for the document one. But even apart from that order, clearly shows the respondent provider as well as has submitted that they have not been given any documentary or evidence that how their evidence were closed. Under the circumstances, subsequent examine the more witnesses rightly considered by the inquiry and afterthought, and accordingly such request was rightly rejected. In fact, on account of the clear admission contained written writing even respected amount of 1484, the charge against that admission and the only question and remain the considered was about the nature of the punishment to be imposed on him. When responded are guilty of misappropriation of such large amount of and all, for a couple of months, it do not be said that punishment is essentially imposed by uncalled for. First thing is the proportionate nature, misconduct him. For the all because High Court cannot be sustained and therefore, who are certified the institution filed with the High Court can be seen, however, the said fact, then I am dealing with 2013. There are 13 6.
Huh? Yes.
2013 6.
We have read that. Para 15. Yes, second reason. Encourage should have allowed the respondent to lead evidence in rebuttal is also without substance in the overall facts of the case.
There are 34, 35, 45, and 46
Of
of 2013 6.
2013 6 SCC, yes.
Coming to para 31 page 327.
Oh, yes.
Mr.
Ah,
Parekh,
34.
Mr. Parekh further submitted that applicant having admitted all the charges filed against him cannot be permitted to resign from
No,
the
kindly come to page 34. Para 34.
We have noted that detailed submission made by Mr. Flores, speaking, it was not necessary in view of the categorical submission made to the applicant before.
We just stop here for 1 minute, sir. In view of the categorical admission made by the appellant before the inquiry officer, in your particular case, the categorical admission, if it is not there, it is not there in the. We will not speak again. You do what you want.
Sorry.
You keep interrupting us. We will not speak again. We will not speak our mind. We will not interact. You say what you have to say. Yes, go ahead.
Sorry, ma'am. We have not noted detail of the details necessary in view of the categorical admission made the appellant before the inquiry officer having admitted the charges understandably. The appellant only pleaded for reduction in punishment before the High Court. Learned counsel judge has clearly noted that counsel for the appellant has only submitted that the punishment is disproportionate gravity misconduct. Yes, that is the admitted and appeal. Then, my lord, I am coming to the page para 35. In our opinion, the other single judge and the divisions bench have not committed any error rejecting the submission made by the learned counsel for the appellant. We are not inclined to examine the issue and the action of the appellant could not constitute misconduct under the rules. In view of the admissions made by the appellant, no evidence was received before the inquiry officer by either of the parties. Once the inquiry officer had declined to accept the conditional admission made by the appellant, it was open to him to deny the charges, but he chose to make an unequivocal admission instead of the reiterating his earlier denial and record preliminary hearing held on 26/12/1994. The appellant cannot now be permitted to rescind from the admission made before the inquiry officer. The plea to reopen the inquiry has been rejected by the appellant as well as the revisional authority. Thereafter, it was not even argued before the learned single judge. The learned single judge has confined to the submission on the quantum of punishment letters and patent repeated. Then, my lord, page 45. Para 45. In now going brings to the reliance placed on the appellant on the judgments and sources. In our opinion, the ratio in the opposite judgment have not relevance in the case. We are not satisfied that in the case of Glare, in our opinion, the punishment imposed by appellant is not disproportionate to the shockingly concise on the ground. The observation of the senator also avail of the appellant injustice, much less given injustice. Then, my lord, I am relying on the judgment of 2011. 2011 SCC. Page 355, para 15 and 16. It is a bank officer's case. The second reason assigned by the
Just a minute.
tribunal that inquiry officer
Just a
should.
minute, give us the citation again.
My lord.
2021.
2011, 11 SCC. It is in the bunch. That is bunch here. My return acknowledgement. Para 15.
Name of the case?
It is a State Bank of India versus Hemant Kumar.
I don't find it.
Para 15.
Just a minute.
The second reason assigned by the tribunal that the inquiry officer should have allowed the respondent the opportunity to lead evidence in rebuttal, it also without substance in overall facts of the case. The respondent had already tendered 2 admissions of guilt in writing and one only before PW1, and therefore has hardly admit anything that could have been said on this behalf of the repeal the charges. We are therefore satisfied the tribunal's findings are wholly unreasonable, unjust, and fit to be set aside. The High Court unfortunately did not consider a matter as it should be. In the light of the discussions made about the High Court's order is equally unsustainable, we accordingly set aside the High Court and we award of made by the tribunal, the appeal is allowed. It is the appeal of the appeal by the State Bank. Then, my lord, our GLT1 judgment I am relying on the GLT. It is a GLT 2021 1 GLT before Honorable Justice Michael. That is a page 77. That is also in the service law, disciplinary proceeding, removal from service, admission. Petitioner admitting the charges in his explanation as well as in the written statement of defense. Inquiry officer holding the charges to be proved. Petitioner also admitting the findings of the inquiry officer in his representation against the finding of the inquiry officer. Appeal not disputing the findings of the guilt, not open to the petitioner to enlarge the scope of the appeal by challenge findings in the departmental appeal. No illegality in the departmental proceeding of the procedure adopted. Altered penalty of removal from service imposed by the appellate authority did not shocking consciously cause intervene. Here, my lord, BC Chaturvedi also relied by the judgment at para 18, page 81. BC Chaturvedi in 95.6 SCC relied on page 81, page 81 of the judgment. Para 18 I am reading of the GLT judgment. The facts of the case as shown above show me that the petitioner had admitted to the misconduct at the time when he was asked to give an explanation and also in his written statement defense dated 15/5/2014. The inquiry report shows that during plenary hearing, departmental inquiry, the petitioner had restricted the admission with regard to some portion of the particulars, which states that the petitioner was found in an intoxicated state on several occasions and that he used to create nuisance, disturb colleagues and so on. Also, he often went outside the battalion headquarters without any obtaining prior permission from the authority threatened. There is nothing to show the pleadings of the inquiry report that the petitioner had restricted the admission with regard to the article number 1 and 2 framed against him in any event. The inquiry officer report further states that at the time of the final hearing, the petitioner fully admitted to all the charges framed so and so, so and so, so and so. There is no denial of the same in the petitioner's pleadings. The inquiry officer thereafter submitted his inquiry report, wherein all the charges framed against the petitioner are found to be proved. Therefore, the petitioner is asked to submit his representation in the inquiry report, wherein the petitioner admitted the findings of the inquiry officer made by the inquiry report, say 76/2014. Due to the above reason and the apex court in the various decision high court, while to enter the disciplinary authority and appellate will have to be considered the sole judge of the facts except then visited by the right, para 18. Review of the above legal position would establish that disciplinary authority and the appellate authority, being fact-finding authorities, have exclusive power to consider the evidence with a view to maintain discipline. They are invested with the discretion to impose the appropriate punishment, keeping in view the magnitude of the gravity of the misconduct. High Court tribunal, while exercising the power of judicial report, cannot normally substitute its own conclusion or penalty and impose some other penalty. If the punishment imposed by the disciplinary authority shocks the conscience of the High Court tribunal, it would be appropriate amounted to do so and so, so and so. Then, my lord, the exceptional case, rare cases imposed precedent. Then here, Lalitpopli relied 2003 TSCC, para 16. It is fairly well settled that approach and objective of the criminal proceeding and the disciplinary proceeding are altogether distinct and different. In the disciplinary proceeding, the preliminary question is whether the employee is guilty of such conduct as would merit action against him. Whereas in criminal proceeding, the question is whether the offense regarding the against the establishment. Standard of proof, the mode of an inquiry and the rules governing the inquiry, conceptually fancy. In case of the disciplinary authority, the technical rules of evidence have no application. The doctrine of proof beyond doubt has no application. Preponderance of probability and some material on record are necessary to arrive to the conclusion whether there is delinquent has committed misconduct. While exercising the jurisdiction under the Article 223 Constitution of India does not act as an appellate authority, jurisdiction circumstance limits judicial review to correct errors, law, procedural, so in violation judicial review. In Visit Authority versus Indian India, the scope of judicial review is indicated by stating that review of the court is of the decision-making process and are findings of the decision court. In view of the fact that petitioner had accepted the findings made by the inquiry officer,
Which part are you relying on, sir? We can't keep reading. Which part? This
Para
judgment?
21.
Huh?
Para 21 of this.
Para 21.
Page 82. Conclusion.
Para 21.
Oh.
In view of the fact that petitioner has accepted the findings made by the inquiry officer in the inquiry report,
Cannot
the
give
finality of the inquiry report cannot be gone into at this stage. This is what you want to rely on?
cannot be allowed to block
Yes.
and cold at this point.
Okay.
The perusal of this. Then para 22, page 83.
Yes.
On considering the fact that while
We have read it, sir. Reading it takes time. We have read it. And
then my humble submission that the petition is to be dismissed because he has admitted repeatedly and on the basis of preponderance probability and on the basis of the Supreme Court law, I have proceeded for this. And if your lordship, I am doing the record after half an hour.
I'll give a quick response, Malad. Perhaps nothing much is required.
yes.
If your lordship will, I overlooked to point this out when I was making my submission. If your lordship will kindly come to paragraph 6 at page 8. Line about 9 from bottom, there is a sentence starting, be it stated herein. Be it stated herein that only the class 1 officers such as branch manager, divisional manager, etc. of the corporation have the authority to adjust the BOCM. This is the submission that I was making. A development officer does not have any authority to make any adjustment. And this has remained undisputed. This has not been controverted. That is number 1.
Just a minute.
The adjustments that have been charged against are way beyond my authority.
They said something. At page 67, the statement in this para that only officials of the corporation have the authority to adjust the BOCM is not at all true.
They have not been able to demonstrate any provision in the regulations which entitles me to make this adjustment. Whereas it is the contrary that is recorded in the regulations that I pointed out. Page 23 and 25. I am not supposed to have any financial dealings.
Yes.
The second submission is, my lord, as I was pointing out, their only sheet anchor is that there is an admission. When I responded to the show cause and when I responded to the charge sheet, there is an admission. On that, my lord, I am just repeating what I submitted at the first instance. Number 1, I cannot admit to something which is not even within my job profile. That is number 1. And number 2, since they proceeded to hold an inquiry, assuming I have made those admissions, since they proceeded to hold an inquiry, merely by saying preponderance of probability, that is not enough. They will have to establish the charges. Otherwise, it becomes a case of no evidence. And if it becomes a case of no evidence, your lordships under Article 226 have the power to strike it down. preponderance of probability cannot mean that even without any evidence at all, someone can be convicted. It will be willing and conceding too much of a power to an authority. They will start functioning like Hitler, which your lordships will not permit.
The mistake repeated by the inquiry officer by not calling witnesses to record their oral statements as well as to prove the documents generated in the course of the preliminary inquiry. The procedure followed is plainly indefensible, and therefore we hold the respondent has been punished without following the due process of law. 2025 judgment, Supreme Court. Unless you can show us that there was some oral evidence laid in the
And,
inquiry.
one thing I have, another thing I like to point out,
Yes.
my affidavit,
Hmm. Hmm.
at page 38,
Hmm.
that is the reply to the shockers notice of penalty 31/3/2073.
Hmm.
He replied. That reply I have enclosed. That
To
is
the
not part of
shockers
the
notice.
repetition.
Hmm.
Shockers to the penalty, which is the
Uh-huh.
last,
Proportional.
shockers to the penalty. After that, he replied.
This is when you gave him the inquiry report.
Page 33,
When you gave him the inquiry report, asking him to show cause. Is it not?
shockers to the penalty, page 38.
That is one further after the inquiry report. This show cause is after the.
After
After the inquiry report, shockers to the penalty, why the penalty would not be imposed on it. Then he replied.
24. This is there at page
38.
55. What
30,
is at page 55
30,
of the
30,
petition? Is it not the same?
same.
So this
this-
31/3/2017,
Same.
it is in reply to 31/3/2017.
Yes.
If it is in reply to 31/3/2017, it is a, and you have stated that it is a show cause to the show cause reply to the
Proposed penalty.
proposed penalty. That means prior to 31/3/2017, you have held him guilty. But by 31/3/2017, you are giving him the inquiry report. So if you are giving him the inquiry report by 31/3/2017,
No, he has not said it.
should you not wait for the reply to come before you hold him guilty and then punish him? But then we had promised not to interfere or interact with you because you.
That is what he replied.
No, we take back our
Well,
observation.
But what my junior could locate one judgment of Justice Roy. This one pertains to CRPF. Here also there was an admission. However, it was held that it was unfair. The procedure adopted. That
What is the name? You got the name?
Nipun Rajbangshi.
Nipul.
The factual position and what was held, I have marked the relevant paragraphs. And I'll try to locate the other.
which have been established in therapeutic practice. So that is
Total is
that is
100
why
level,
Lordship, they have given the all the calculation in their petition. Now Lordship will kindly see paragraph number 11. So that is the gist of their submission, Lordship. Now in the paragraph, Lordship, 22, Lordship. Thus, it is evident that the whole quantity of material recovered in the form of mixture is to be considered for the purpose of determining the quantity of psychotropic substance, and when the psychotropic drug is kept in possession without any document to show that it was meant for therapeutic use and the gross weight of psychotropic substance is well above the commercial quantity, the restriction under 37 will apply. Thereafter, Lordship, 23, again one notification was issued by the government, Lordship, which states, Lordship, that it is essentially a narcotic drug that I have stated.
We have read it.
Yes, and just to clarify on that point, Lordship, this is the judgment of the Supreme Court. It has also stated the same fact, Lordship, that it has to be for therapeutic use. Otherwise, they have to have a license or they have to give that explanation, Lordship. Here, Lordship, I'm just quoting the paragraphs. Paragraph
No, we
number
are not
5.
going,
Lordship.
while considering the bail, we are not going so
Yes.
deep into it. The only issue is
No, I
there
was,
were two vehicles.
yes,
3 persons have been arrested.
yes,
Petitioner says that, yes, I was a delivery boy.
yes,
That Ace van is for delivery purposes.
yes.
I was asked to transfer the boxes. Even if we go to that extent, she says he reached late and was later picked up.
Yes.
Even if he was transferring the boxes, can a delivery boy be?
Lordship, for that, Lordship, 37 will come into play. Lordship will have to take the satisfaction that he is not involved in the offense. And Lordship, that therapeutic practice is very clear, even by the Supreme Court, Lordship, paragraph number 6, Lordship will see. Why I'm submitting, Lordship, because in that bail
No,
application.
even if it is not a narcotic,
Yes,
even then it will come up, coming
Yes.
37.
yes, because Lordship, it has to be only for therapeutic purpose, Lordship, because codeine.
How do you
mixture
say
is
it
to-
is not for therapeutic purpose? When,
Lordship, there has to be license for sale transfer. Lordship will kindly take up HC.
we are not on
not
that.
transfer.
That is on a presumption that he was actually involved in the transfer of everything.
Lordship will kindly take up the NDPS side.
That he was actually involved in the
Yes,
transfer,
yes.
then whether 37 and all will
It
come in.
cannot be transported without a license.
But he is a person who's transporting, who's a delivery boy,
In
Lots of
Flipkart,
it-
ma'am.
changing a box from one car to another.
Yes, they were taking the container from one to and delivering it to somebody else. So they are involved, Lordship, because without that knowledge, Lordship,
You have not made
cannot-
any statement that this.
I am not
Yes.
transfer the cartoon, my lord. Way to transfer the cartoon, my lord. Some Rajiv Arbet and Kutubali, my lord. I am sitting in the Flipkart vehicle, my lord.
Where is your Flipkart iCard?
I got my lord annexer A, my lord. Page 8.
once when possession is established, the reverse burden is upon them to establish. Lordship.
Huh?
If I am
Reverse burden will come now to them, Lordship. They will have to discharge the burden, Lordship, whether.
faced the
NDPS
trial, my lord. I am not apprehended in
You need him in
investigation.
custody as of now is what we are trying.
Yes,
to say.
I am
Lordship, the
just
evidence has
trying-
not yet started, Lordship. At least some evidence may have to be.
I am-
The
I
restriction
am-
37 is always there.
Age, my lord,
Because
only
from-
27 years old age, my lord, boy.
That
And
makes it
24
more,
female.
that makes it more dangerous.
27 years,
The-
and if he is entered a jail, my lord,
The
that is the
accused is
jeopardy.
more, that is what. Outside, if he's going to do the same thing again, he'll be trained up well.
He newly joined the Flipkart company, my lord. He is the newly joined the Flipkart, my
You
lord.
will kindly see.
And he is no knowledge about the
NDPS
incident, my lord. He is, by mistake, he is police suspect,
Huh?
my lord. Police
This-
arrested merely on suspect, my lord.
Because this kind of grounds, Lordship, are
No
coming.
man idea. And main culprit is opened a year, my lord. He is the main Venu owner. He
That
is
makes it,
involved.
that submission makes it more dangerous. Even if he comes out, both of them flee together, what would the police have in
He
their
is,
hand?
he is no knowledge, my lord. He is the waiting for the vehicle,
What
my
we
lord.
do is, evidence.
Yes, at this stage, Lordship, it may be rejected, Lordship, because.
My lord, I am faced the trial. I am the local
The
person.
grounds that have.
If I am released on bail, I am not apprehended by police, my lord, and not absconding, my lord, and not hamper and temper the trial of the case, my lord. I am appear the trial court and face the trial, my lord. If I am guilty, then I punish the trial court, my lord. At this stage, I am allowed to go on bail, my lord. His age is 25 or 26 years old and is newly and very poor family, my lord. And here he is only employee of a Flipkart and father is the
Not
18
that-
years.
We are not convinced at this stage, madam.
Yes, my lord, he is not involved in this case. And recent
The number of bottles being carried is disturbing us.
my lord, in 1 January, 1st January 26 notification, my lord, that is the clearly stated that cough syrup is not enter in the drugs. And K is the
Carrying of rice is not, or carrying of cows and buffaloes do not require any specific
no, my lord.
permissions. But when there are 16 cows in a truck,
No, my
it
lord.
becomes difficult.
He is
There are 600 bottles. How many bottles?
no, 294. And
94
on
bottles.
the my
one
lord, this is
vehicle.
the intermediate quantity, my lord. 100, I have already
We'll
calculated.
pass orders. We'll
Yes.
pass orders. We'll pass orders. This was the
Note 8C Lok Sabha qualification.
Two article available also, no?
This case may
Ah.
not be a fit case for mediation, my lord.
Yes, madam, salary,
Yes.
Areas.
Areas.
what do you say? Goes for mediation, not goes for mediation.
It can be decision of on one date if you're not fixed. But this may not be fit for mediation.
Not fit for mediation. Learned counsel submit that the matter may not be a fit
date
case for
will be-
mediation. List this matter again, you'll have it on April or March. March end or April. April or Bihu again. No, Bihu again into other meeting. April 20th of April 20
My
for
lord.
admission. Hmm? No, the parties submit will go to you. They are not, the matter is not fit for mediation. Yes. Yes.
May please alert.
Ah,
May not be a fit matter, my lord.
well,
So the petitioner is a hearing impaired person.
yeah.
He would be needed one interpreter with him. And the
To do what?
matter involved in this case is he has not been paid a single penny for his salary
From,
from my lord, his date of joining.
how do we know that? Tell us the date.
My lord, it is from 1/6/2023.
23. We'll have it again in April.
If my lord,
1st of April.
but can it be taken after 2 weeks, my lord?
February, we are done with. March, we are trying to accommodate. We are trying to accommodate
Then a
matters.
fixed date, my lord.
We are giving 1st of April.
First of all.
Learned, the Learned Council for the Higher Education Department has paid for an accommodation to file their affidavit in opposition. Time allowed till 6th of March 2026 to file the affidavit in opposition. Non-filing of affidavit in opposition till such date will be constituted to be non-cooperation in adjudicating in the matter. List the matter again on the 1st of April, allowing some time to the petitioner to file his response. If you don't do it prior to 6th of March, we will hold that you don't want to decline. 6th of March.
Not that line.
Oh, that line has to be there in every case. That line is there.
In fact, on 18/6, my lord,
Huh?
18/6, while issuing motion,
Huh.
my lord, they were said to take instruction why salary is not paid. My lord, till date, 8 months have gone by.
We'll do it on the 1st of
Well,
April. We are not keeping matters pending
Well.
like that.
Item 5 to 7.
Again, salary.
These three matters, I have talked with my client,
Ah,
they are agreeable to take a try before the meeting.
it was agreeable for mediation. Based on when it will be possible. We'll keep it on the
At least, Lordship may put after 2 weeks so that
27th of
February.
February
That
for
will be-
mediation, before the mediation.
Yes. Obliged,
From
all the three.
all the three. 3টা দিছে একেলগে।
I think 8 to 10.
May I please?
Yes.
I am there in respect of item number 9 and 10, my lord. And
Hmm.
8 is there.
Hmm.
I with the consent from with my client, my lord.
Hmm.
Please before mediation.
Mediation.
By
At the consent of the learned counsel for the parties, we place this matter before the mediation center. On 27th, parties would appear on the said date before the
okay.
mediation center. Registry to do the needful.
All right, this one, I think 240.
It will part, we'll finish it. Singhania University. Hey, Eric Mackenzie. We talk on law to come.
Lordship.
2 minutes will, now we are taking time. Counsels will be heard after some time, 2 minutes.
Lordship,
Huh?
otherwise, can this matter be taken apart through Lordship?
Let's see, it was kept part.
Yes, Lordship. But
For whom?
Mr. K. Gogol.
K. Gogoi is supposed to address this honorable
Yes.
regarding.
Singhania University.
Yes, Lordship.
You want this at 2? We pile up everything at 2 and then we go slow. If we keep piling up for 2 o'clock. All right. Not hard. At 2.
Obliged, Lordship.
It's okay.
May I please, the Lordship?
Yes, sir.
Lordship will kindly see the last order, my lord, 27/1/2026.
Lordship directed to place some
Hmm.
instruction.
Is it here? Do you have the instruction?
My lord.
What do you have?
As per my instruction, my lord, in 2009 and 10, my lord, the name of the petitioner is there, my lord.
In the dice code.
As per 9 and 10.
Hmm.
Subsequently, my lord, his name, the
Disappeared.
advertisement and 9,
Then it disappeared.
my lord.
His name is there in 9 and 10.
Yes, but this is the.
So should we pass an order or should we? Would
As
you
your
make the
lordship.
corrections? Huh? Where do you find it in the dice code?
At annexer 1 or 2.
Your name is?
Irshad Alam.
Yes, sir.
So this is for year of J. What is YOJ? Irshad Alam is at number 2.
Yes.
What is the name of respondent number?
Abdul Aziz.
Abdul Aziz.
Abdul Aziz. He comes in the year 2019. Poop Amloki AS Ahmedia.
Yes.
That is the school.
Yes.
He was there in, Abdul Aziz is there in 1999. He's there in 2000. 2000. Oh, the year of joining. That is the year of joining. How do we know which year? Is it 14, 15?
My lord, the
This
start,
is 9, 10. 9, 10.
That's
Irshad is there.
Irshad is there. This is the criteria, my lord.
Then
As per-
10, 11, you are not there. Why?
My lord, that I cannot say, my lord, why my name was not carried out by the authorities.
Oh, that is what the CRCC has said that
CRCC.
sometimes it was not done correctly.
Yes.
11, 12, it was not done correctly, and Abdul Aziz comes in 11, 12.
Yes. But the act says, my lord, it has to be 2009-10 or prior thereto.
Yes, sir. Is your name there prior to 910?
My lord. So far as my lord, the 910 is concerned, my lord. My lord, in our affidavit, my lord, we have submitted one form which is required to be submitted by the headmaster.
Where is the
And my name is, my lord, in the form,
form? Page number?
page number, my lord.
at page, my lord, 80,
Huh?
80, annexure I.
Huh?
It shows, my lord, serial number, dice code of the school is shown same dice code. And that application was forwarded by headmistress by under his seal and signature. So had it, my lord, not been in the dice code, why is the question to her, my lord, forward my name? On the other hand,
Page
my lord,
number 80. Page number 80 is the application form.
application.
No, application, we are asking about the dice code prior to 910.
Prior to 19 or dice code, my lord.
Your name did not appear. Your name did not appear.
For the first time, prepared in 2009.
Is it? 910 is the first time dice code appears. Or how do they say prior thereto if there was no dice code?
My lord, if I may clarify,
Ah,
my lord, dias code is required to be, my lord, prepared right from the 2009 or 10 or prior to, meaning thereby, my lord, if somebody has the dias code prior to 2009 or 10, that will
no
also
chance
do.
for the
But so
SSA.
far as our school is there, my lord, it was prepared right from the 2009 and 10.
We just need to know this dice code, when did it start? Just ask him. Yes.
Normally,
Ask
my
him
lord,
and inform us.
my lord, normally, my lord, in most of the schools, my lord,
Hmm.
it is started right from the 2009 and 10. My lord. I have done many cases. My lord.
If I remember
2009.
correctly, it is 6-7. If
Not
I
very well.
remember correctly.
So far as, my lord, all the, my lord, regarding the dias code, my lord, most of the people, my lord, furnished.
But you were not there in 910.
Yes, it is the credit. He is not there, my lord. He is admitted, my lord.
But I think the appeal question. Therefore, I pose a question for myself. But a dice code, they have very important documents. So when the provincial part is concerned, who is to prepare and on what is the basis of preparation? If there is no.
See, if it had been a case where you took a stand that your name was excluded from the dice code,
Yes, that is-
just like him,
that is-
then it's a different matter.
That is my case, because affidavit in affidavit, I have taken a specific, my lord, stand. My name was dropped. Therefore,
From which year?
From 2009, 2010. The whole inspection report, inspected by the competent authority, since 2005, my name reflects. So why should I not pose a question for myself? What is the reason to drop my case name from 2009, 2010 dashboard? And what is the basis to prepare that particular dashboard? Oh, I must have prepared for it.
Must have known as district members.
Used to forward the materials. Therefore, my lord, that time, my lord, file an affidavit, I will file an additional affidavit. I will raise this question.
No. His
Otherwise-
name has been rejected. His name was not taken into consideration
That's right.
because,
Now disputing that.
just a minute, so let us finish. We allow everybody to finish. We would appreciate if we are allowed to finish. Where is your that provincialization order?
You know, that provincialization order in the writ petition at page 28, my lord, annexure 9
28.
of him, my lord. Explain number 6.
This 28 order
Yes, provincialization order.
and your recommendation did not take into consideration the fact that your name was absent and it had been forwarded.
Yes,
Therefore, the name has to now, this provincialization order has to go. And
yes,
since his name was there,
yes,
the DLC has to consider his name.
yes,
And also, if you can show before the DSC that your name should have been included in the dice code or was dropped erroneously or whatever had happened, it will be upon you to do what you have to do. We'll give you all the liberty. But your inclusion, inclusion of the name of your client in the provincialization order when the name was not there in 910 is wrong.
yes.
Therefore, the question will arise, my lord, we will answer this.
That we will answer in an
I will put this question.
uh,
What is the basis of?
in a appropriate proceedings
Fine,
which you would initiate,
fine.
Yes, my lord.
not in a proceeding initiated by the petitioner.
Just put on filing a writ petition.
Yes,
Give me, my lord, some liberty.
we will, yes, definitely.
Because, my lord, the
Let
question, which strikes me, my lord,
Yeah.
what is the basis of impeachment as to?
Oh, yes.
There must have some
It
basis.
will be at, you will be at liberty. And once the question is before us, our attempt would be to answer the same.
Right.
And my lord, that
Her-
fundings, whatever fundings is, my lord, supposed to be arranged by this court, that funding may not have any bearing. Otherwise, tomorrow, my lord, if I do file a suit, then my
Ah.
lord, they will come and say, already court is arrived at a conclusion.
No. We'll give you the liberty. We'll say that you would have all the liberty to assail and project and do whatever you want to.
But I will file,
Yes.
my lord, I'll file
এই
it next
আগৰ
week.
অৰ্ডাৰটো 27
So, my
2016
name,
অৰ্ডাৰটো
independent faculty matter for next week.
It's passing.
ঠিক আছে।
First.
Next upon the The matter has now been listed today again. And the learned counsel for the Department of School Education has produced the instructions dated 10th of February 2026, by which it is now clear that the name of the petitioner had appeared in the Dias Code of the year 2009-10, whereas the name of the petition of the respondent number 6 did not appear in the Dias Code of 2009 and 10, though it appeared in all the Dias Code thereafter. Full stop. Ironically, the name of the petitioner started missing on from the Dias Code of the year 2010-11. Thereafter, your name is not there. Full stop. The requirements of the Provincialization Act of 2017 is the presence of the name of the proposed persons to be included in the Dias Code of the year 2009 and 10. Since records now reveal that the name of the respondent number 6 did not appear, respondent number 6 did not appear in the Dias Code for the year 2009 and 10. The provincialization order dated 5/2/2021
Yes.
has apparently been issued on the basis of a recommendation which did not take into consideration the aforesaid record. Full stop. In such view of the matter, this court is of the opinion that the recommendation by the DSC and the further action taken on the same by the state level committee and the other respondents to provincialize the services of the respondent number 6 when his name did not appear in the Dias Code of 9 and 10 requires an interference of this court. Accordingly, the order dated the provincialization of the respondent number 6 given effect to by the order dated 5th of February 2021 is set at naught, as are the recommendations of the District Scrutiny Committee and the other authorities forwarding the name of the petition of the respondent number 6 for provincialization. Full stop. This is not to say that the respondent number 6 would lose all his rights to be considered for provincialization in case he takes up a stand that his name was dropped from the Dias Code of 2009 and 10 for the particular concerned school, and he can bring on record materials before the District Scrutiny Committee or other before the appropriate authority. District Scrutiny Committee, if he can bring on record proof of a proof before the concerned authority to establish the fact that though his name should have been included in the Dias Code of 2009 and 10, it was dropped inadvertently. It was dropped out, and therefore his case would require a consideration for provincialization in accordance with law. Full stop. Mr. A.K. Prukasto has prayed that the respondent number 6 be given the liberty to agitate his claim before the concerned authorities for provincialization. Mr. A.K. Purkastal and the council paying for the respondent number 6 has prayed that he will be given the liberty to agitate his claim with regard to the dropping of his name in the 2009-10 Dias Code and for any benefit that would have arisen out of and if his name had been included in the said dashboard before the appropriate forum of law or before the appropriate forum of law, full stop. This court does not see any reason not to grant the liberty, and therefore the liberty as prayed for is granted, full stop. Coming back to the case of the petitioner, it is apparent that his name had been included in the Dias Code for the year 2009 and 10. No reasons have been assigned by the respondent authorities in their affidavit in opposition, other than the absence of the name of the petitioner in the Dias Code of 2019 to have denied him a consideration for provincialization.
Yes.
Full stop. Now that it has come on record that the name of the petitioner was available in the Dias Code of 2009 and 10, comma, the respondent authorities, no, the Director of Education, the Director of Elementary Education shall require the case of the petitioner to be routed through the DSC along with all appropriate and relevant documents
Yes.
for a reconsideration of the case of the petitioner for provincialization under the Act of 2017 in accordance with law. The petitioner shall appear before the office of the Director of Elementary Education on or before
Lord, first
15th
week of March, my lord, any date, my lord.
first week of March. Everybody will be colorful. We'll have it on the second week of March.
Yes.
13th of March 2026 with all the relevant documents available with him.
Right.
Full stop. The Director of Elementary Education shall cause an inspection of the documents required to be submitted by the petitioner, comma, have the same accepted, and thereafter proceed to have the matter of the petitioner reconsidered from the level of the District Scrutiny Committee onwards for consideration of provincialization, full stop. If the petitioner is fit to be provincialized, is found fit to be provincialized, if the petitioner is found to be fit to be provincialized under the 2017 Act, comma, the director shall, the respondent authorities acting in cooperation shall ensure that the petitioner is granted the benefits of the requisite orders granting the petitioner the benefits of provincialization are made available to him within a period of 2 months from the date of receipt of a certified copy of this order, full stop. Needless to say, in case the petitioner is found to be eligible for provincialization under the 2017 Act, comma, the benefits as has been given to other people who have been provincialized under the said Act shall be made available to the petitioner, full stop. Writ petition disposed of, no costs. Yes, sir.
Coming forth.
Hmm?
How I will file a petition. Now, obviously, I will make it fair for stay. Because once they allow me to continue, once the court has set it not, in order, then it will be very, very difficult on my side.
We have set it at naught even before they start a process. Day after tomorrow morning, you can have a stay. There are appropriate forums.
My lord, till that this provincialization order should be set aside.
It has been set
Yes,
aside.
my lord. Deeply.
So I will not be in a position to make it fair for stay.
Because you see, unless 2019 does not continue in him,
Yes, my lord, that is.
this court has
apparently-
no option.
That is as
This
per
court
the-
is the last court which would try, which would interfere in the livelihood of a person. If there is some semblance of a lawfulness in it.
For the end of justice and equity, some liberty may be given to me so that I can approach the court and make it fair for appropriate.
What kind of a liberty? We have given you the liberty that Mr. Purkayasa submits that he should have his client should have the liberty to approach the appropriate forum of law.
That's right.
Yes.
That liberty is granted.
Yes,
That's
my
right.
lord.
So far as the interim relief is concerned. And court will
In
not
this
be
writ
able to-
petition, we should presuppose that you would want to file a writ petition where your interim prayers would be considered.
That's why, my lord.
Can we give that?
So, my lord, to protect my interest. This 7 days
Lord.
time may be granted, my lord. They allow me, my lord, the present position to continue.
No, once we find it illegal, we cannot do that.
Yes, my lord, apparently illegal.
Once we find it illegal, we cannot do that. Okay, have it like this. Okay, have it like this. On the setting aside of the provincialization order with regard to the respondent number 6, comma, Mr. A.K. Purkayastha, Lord Council has submitted that since the provincial consideration of provincialization of the petitioner may take some time, and in the meantime his client would be out of service, comma, it may not be feasible for the school to function in the interregnum, full stop. It is left open to the state authorities to act in a manner in which the educational atmosphere of the school is maintained.
No, that may not be.
They will do it. They will do it in
That
some.
may not be necessary, my lord. This is my humble submission. The last my lord observation.
Come back immediately. We have not said that they will allow.
That
him
is
to-
not required, my lord. It is apparently, my lord, from the.
What
report
about
of
the school?
direct-
What
Yes.
about the school?
My lord, I'll leave it to your lordship.
Just tell us, what about the school?
I'll leave it to your lordship. my lord.
There is one teacher provincialized.
Yes.
He is out.
I
What happens
understand.
to the students?
I understand that. I'll leave it to your
Is it not? So we'll have to
Yes.
leave it open to the respondents to run the school in a manner they deem fit.
My lord.
Oh, that's.
Yes.
Deeply, my lord.
City has recorded.
I think bank 16 to more than 16.
This is item 16. We'll hear you also. Just yes.
Yes, relates to compassionate at appointment, like,
Ah.
I don't, earlier, Lordship, my case was rejected by, accepted by the district level committee and forwarded to the state level committee, Lordship. State level committee has rejected my case showing that want of vacancies. So I have
So
the,
if there is a want of vacancy, what can we do?
Lordship, I have the judgments of this division bench also, Lordship. That this, since district level committee has recommended my name, Lordship, against 2 vacant posts, Lordship. But state level committee cannot reject on that ground, Lordship. There is a office memorandum also, Lordship. They may accommodate in any department also, Lordship. And I have the judgment of division bench also, Lordship, that showing that ground, Lordship, state level cannot reject, Lordship.
2020. When did your father die?
Lordship, died, Lordship, on 17/1/2014, Lordship. And Lordship, state level committee has, Lordship, will find 18 January 2020 meeting was held, Lordship. And I have approached in the year
18?
2021, Lordship, I have approached.
No. From 14, you filed an application. When did you file the application?
Lordship, in the year 2014.
2014. From 14 to 20, what happened?
20 state district level, state
What
level has
happened from 14 to 20? What did you do? No grievance.
Lordship.
2020, someone rejects you.
Lordship, 2020 in the year.
Then you come back to this court saying that no, this rejection is wrong.
Yes, Lordship. After
6
rejection,
years gone. 6 years gone.
Lordship,
No consideration.
no consideration.
Then compensation.
Lordship, compensation part, Lordship, there is a judgment, Lordship, but since division bench also passed an order, Lordship.
When?
Lordship, it is the.
We'll come with the most recent division.
I have
judgment.
the judgment.
The most recent one.
Yes, Lordship.
What does it say?
Compensation of 1 lakh.
That is all. But the
But that is the
consideration for
order of
compassionate
civil
appointment, it has to stop somewhere. It has to stop somewhere. A person, the compassionate appointment scheme was something which was a boon from the heaven. It was a compensation for what God did. Is it not? Can you make a right out of it?
Lordship, refer before the state
It is
level.
the way of the world that you have to make way for whatever is coming behind you.
Lordship can refer the matter before the state level to reconsider, Lordship.
This one.
Lordship, at
Consider.
present, there is no state level committee because as per the direction of the honorable court, everything has been done, Lordship. So it is almost in the fag end.
Now,
Lordship.
if we now again push it with the present division bench judgment that those who would require reconsideration, we'll be adding up cases to the state level committee, and still state level committee will function like the high power committee of the education department. It's still functioning, set up in the year 2002 or 3. 25 years down the line, it is still functioning. Can we do that? We'll have it at 2. And we'd like to close it at 1 lakh. That is what we would like, if you, unless you can convince us otherwise. Yes, sir, Mr. Ghosh, you were making some.
The indulgence of my lord, my lord, so far item 33 is a hearing matter, 2015 matter, I know, my lord. But the thing is that the change of the lawyer, my lord. First, Mr. Justice Nair was handling the case, my lord.
Okay.
After elevation of the bench, the brief have been handed over to my associate, my lord. Now, this has been handed over to me just this morning. my lord.
Well, which item are you saying?
Item 33, my lord. I just seek a little accommodation from my lord. This is 2000, otherwise I would not have make a
Mr. B.J.
submission. my lord.
Ghosh, learned counsel appearing for the petitioner, and submitted that he has been handed over the brief
This morning. only, my lord.
today morning, and therefore
Yes.
he would request an accommodation to make himself acquainted with
Yes,
the
yes.
case. List this matter again in, give it in, is there something urgent, what is the prayer?
Mal prayer for increments, I mean.
We'll have it in April, 22nd of April,
Lord.
2026,
Oh, Lord.
for admission, for
Lord.
hearing.
Hearing, my
For hearing.
Lordship, I also beg for an indulgence, Lordship. Item 45, if it can be taken up at 2, Lordship. The officer concerned has
Item 45, we directed a personal appearance.
directed there.
Huh?
So if it can be taken up at 2, Lordship.
What is this? Deputing of representative of responsibility
Yes,
for
sir.
proposing along with necessary records. Okay. That, is it that, what was this matter? That took, that, you have flag mark. A education, record education, record techniques. Purpose silent, the records are here. He has flag marked the relevant part. We'll just try to find out. Where is that white flag mark? Minutes of regular hearing. Have you seen the records?
That portion he has shown me, my lords.
Which portion there?
That
White one.
minutes of the hearing,
Ha.
regular, that portion, my lord.
Hmm.
My lord, I have seen one thing, my lord, that the petitioner therein solely relied on the reply submitted to the show cause notice, my lords. That is all he has relied upon. The reply dated 12/4/2016, my lords. That only I could see, my lords. I could vaguely see the records, my lords, but that just got into my eyes.
Any difficulty in giving him some time to go through it? Although we have kept the judgment reserved, but let him find out if he might have something to say. Because in your presence, you just let him see in your presence. No, show him again. He said, I have just gone through cursorily. No, everything just show him. We are not arguing the matter any further.
My lords.
Anything to your benefit or to his detriment, you can show us.
I'm so grateful, my lord.
Yes.
May I please, Your Lordship?
Huh.
A short accommodation is required for item number 42.
Why? At this hour?
Mr. B. Prakash has some personal difficulty.
At this hour. He did not have difficulty in the morning. At the request of the learned counsel appearing for the petitioner, not objected to by the learned counsel appearing for the respondents, list this matter again on. What is the matter about?
First week of March.
What is the matter about? Huh?
Health Department matter.
What is the matter about? 22nd of April, 2026.
DP, it is. Apply the.
Yes.
Last one. He is serving officer of Agomani Revenue Circle Lordship. Presently, the petitioner is working under the.
In
Actually, Lordship, the period pertains to where he was earlier, that is working on. So whatever he is with him, Lordship, he forwarded. The last occasion that we submitted, Lordship, that this has been forwarded, and from the revenue, they are telling, this has to be with some observations were there from them, Lordship. So he is not aware about these things, Lordship.
Okay, now that he's now aware, now you are aware, the suspension period has been done away with. It has been regularized for all purposes, if I'm not, is it? So now once that happens, whatever the area salary or whatever subsistence allowance has to be paid for him for that period, he must have been paid first 50%, then 75%. Maybe, maybe not, we don't know, but there'll be some arrears. How long would it take for you to process the same? Have you sent the proposal?
Yes, Lordship, it was sent. Then there were some observation, Lordship, because the regularization period, something only it has been regularized, Lordship.
Who has
Nothing.
to
This-
pass the final order regularizing it as whatever? Who has to do it?
Lordship, now.
So you would explain to him.
Yes.
Huh. Where is that regularization order?
Lordship, Lordship, I have a copy. It has been.
It's not been brought on record, Lordship.
No. You have withdrawn the department proceeding itself.
Yes.
Ah. To the Deputy Commissioner's office.
District Commissioner is to address on that particular thing.
Mr. So-and-so, learned counsel, heard Miss So-and-so, learned counsel, appearing for the petitioner. Mr. Your name is, sir? Hare Krishna Deka, Commerce Circle Officer, Agomoni Circle. Agomoni Circle is present before this court in compliance of the earlier order passed by this court requiring the presence of a responsible officer. Full stop. Ms. M. Bhattacharjee and Mr. J. Handy have, learned counsel have submitted that the officer has been explained the difficulties and the queries raised by the finance department in clearing the arrear dues of the petitioners. Full stop. The circle officer, Agomani Circle, has submitted before this court that he has understood the nature of the queries and would apprise the appropriate authority, that is the Deputy Commissioner, regarding the requirement to be done for processing the arrear salary of the petitioner. Full stop. It is seen from the records that the Deputy Commissioner Dhubri had withdrawn the departmental proceeding drawn up against the petitioner and had reinstated him in service. Good stuff. List this matter again on 27th of April 2026, by which time the Deputy Commissioner, the office of the, what do you call it, the authorities at the district level shall ensure that the queries made by the finance are met with, and the respondents at the directorate and the secretariat level shall ensure that the proposals are put up before the finance department. Stop. Mr. Hendik, we failed to find it here. That is a difficulty. Stop. Mr. Hendik at this stage has submitted that the period of suspension of the incumbent concerned has not been shown to be regularized, has not been shown as to how it is required to be regularized. But
Lordship,
here you have said for all purposes. You are giving indications.
copy of the instruction has been given to me on previous occasion, and in that it is said that it has been regularized and made on duty.
Where?
Lordship, a copy of the instruction has been given to me on earlier occasion, Your Lordship.
Eh? I think that this. I think the deputy commissioner has to be further instructed. It's a dangerous situation.
Yes, Lord.
Have you seen this?
Has to be done.
This is a dangerous situation. Where is 7-9? We have 1-9. This is 1-9. Oh. Have you seen the comparison of these two? The gun will not be on our shoulders, sir. Sorry. Have you understood what has happened?
Shown him.
What is compliance? Nirdek morme. Is it not? Nirdek to mani pelai mo korisu. You will not find one order in the repetition saying that please regularize it. You could have regularized it as anything. It would be for him to challenge. Why the words?
Exactly.
Then what do we do with this? We have seen many letters like this when a repetition is pending. There is a in compliance of the orders. We'll have to make an observation today. Yes, what did we say? That the period of regularization or the period of suspension had not been regularized till the proposal was sent in the year 2023, full stop. The letter counsel for the petitioner has produced before this court a order dated 29/2025, which she asserts was supplied to her by the learned counsel for the respondents on an earlier hearing date, comma, that the suspension period of the petitioner was already regularized and treated as on duty, full stop. We have gone through the letter, full stop. The District Commissioner Dhubri has in that said order stated as thus. You take from this A to A. Huh? This court has gone through the, it has to be before, just a minute. It is surprising that the District Commissioner Dhubri has passed this order in purported compliance with the instruction of the Gauhati High Court in WPC 2680 of 2025. Full stop. This court has gone through the previous orders passed by this court prior to 29/2025 and does not find any direction, order or instruction to the office of the Deputy Commissioner to treat the suspension period of the petitioner to be regularized and treated as on duty, full stop. This court cannot accept that the period of suspension of the petitioner was has been regularized and treated as on duty in purported compliance of the instruction of the Gauhati High Court in the present writ petition. Full stop. In the circumstances above, the Deputy Commissioner Dhubri shall file an affidavit before this court prior to the next date of listing, bringing on record the documents based on which the statement that the period of suspension of the petitioner was required by instructions of this court to be regularized and treated as spent on duty. Good stuff. Yes, when can the affidavit come? No.
27th April, by March 31st, we will be filing it.
We have fixed it on 27th April.
27 April, Lordship.
The
Filing by 31st of March, Lordship.
Huh?
We'll be filing by 31st of March.
affidavit aforesaid be filed by 31st of March. Huh? It would be better for you if you don't proceed with this order, sir. Once this in compliance remains on record,
Lordship, yes.
the person who signed it
And
may be given all sorts of work except administrative work.
Yes. And he is now.
It would better be in logistics somewhere.
He is transferred out, Lordship. He is, presently he is not that, Lordship. It's only a month, Lordship.
No, then we will not ask the Deputy Commissioner of Dhubri to do it. We'll ask the person who signed it to personify.
Signed, Lordship.
It has been submitted that the official who had signed the order dated 29/2025 is no longer holding the office of the District Commissioner Dhubri. Full stop. The respondent number, his controlling authority would be one, or his controlling authority is one. Commissioner and Secretary, Revenue and Reforms.
Personal actually, Lordship.
Huh?
It should be personal
No,
department.
who is his controlling authority?
For district lordship, it is the, this cadre as controlling authority is the personal.
The commissioner and secretary to the commissioner and secretary, comma, personnel department shall be informed about this order of this court by Ms. Bhattacharjee, learned additional senior government advocate, and the commissioner and secretary of the personnel department shall trace out the official who had issued the order dated 29/2025 and the affidavit required to be filed as herein before shall be filed by the particular official concerned on or before the next fixed. List again on, I fixed the date, no? 27/4.
Not earlier.
Huh?
No.
No, let them find out how
Lots,
this
lots.
compliance of orders is coming up. When we dispose a writ petition, it's a contempt.
Lots.
And when a writ petition is pending,
Lots.
it is in compliance.
Deeply obliged, Your Lordship.
Huh?
Deeply obliged.
Yes, any
I'm
any
sorry, my lord.
submissions more to make?
My lords, not as such, my lords. Only thing, my lords, that in the query posed by the inquiry officer, my lords, the only two documents relied upon by the petitioner is my reply to the show cause and my reply to the charge sheet, my lords. That is all, my lords.
Okay,
I'm so obliged, my lords.
this is item. You have to put in, yes, sir. Yes, Mr. Gogoi.
My lord.
But Singhania University, first of all, is not a recognized university.
Just a minute. They were regularized. Petitioners were regularized, but they have not been paid their salary. Is that the case?
Yes.
What is-
Their
huh?
PhD degree is under check.
PhD degree.
They are not on that. Huh. Ah. Okay. So now they say that we have got the PhD degree from Singhania University, and your stand is that your PhD degree is not valid, and therefore you have not yet attained the
Yes.
conditions for payment of regular salary.
Yes, that is the.
They are getting the regular salary, but UGC scale of pay.
Scale of pay will only come if their
Fulfill the UGC.
if their PhD is a recognized PhD or a valid PhD.
Oh, yes. That is the case.
Okay. Tell us.
Singhania University is not a recognized university.
My lord,
Till now, not recognized.
Singhania University is a recognized university, and in last occasion in the year, my lord, 2026, issued a 2025.
Who issued?
16th of January.
Who issued?
UGC.
Ah.
UGC issued banning the university not to enroll for further admission.
Ah.
That order was challenged before the Honorable High Court of Delhi. And that resignation and that order was set aside by the High Court of Delhi.
Hmm.
As because the Singhania University is a recognized university. And it is established under an state act.
Hmm.
Now, my lord, my submission before this honorable court relating to non-acceptability. And that is, my lord, Delhi High Court order.
Where have you stated, Mr. Somua, that it is not a recognized university?
Lordship is taken which case, my lord? Mitali Sharma.
No. Arsana Gagoi.
Orsona Gogoi.
Archana, my lord, we have not yet filed affidavit, but in
No, you
Mitali.
have filed an
File
affidavit.
affidavit.
Oh, sorry. So
Have you said so in Mitali?
yes, Mitali also we have filed, my lord.
Mitali will have not.
My lord, the affidavit filed in the Archana Gogoi, my lord,
Hmm.
is not an extensive affidavit, my lord. We need to file one detailed affidavit.
In Orsona Gogoi. So she was Mitali Gogoi?
Yes, my lord. Sorry,
Mitali Sharma.
Mitali Sharma. We filed it, my lord, Mitali Sharma. Perhaps it starts at page 134, my lord.
Ah, yes.
By Dr. Supriya Dahiya.
Ah, yes.
Madam, may come to page 11 below.
You have done it through distance mode.
No, my
Yes.
lord. That is they are saying, but we are in campus study.
How do you say you are in campus study?
Yes, my lord, it is the respondent number 2 issued a notice to the university after filing this writ petition. On that letter, the university also replied.
Now, how do you say that you were there? Were you doing your duty here or you were doing your duty there?
No, my
Milord,
lord.
they,
I am not.
Do you have attendance here for that period in this?
No, my lord.
You were on study leave.
Sometime we appeared before the classes and
In PhD.
no, my lord, in colleges, on due permission. In Mitali Sharma case, with due permission, we pursued the PhD degree.
Okay, then we'll take it up one by one. In Mitali Sharma case, the pleadings are complete.
my lord, may
Orsona, we may require some clarification.
detail.
No, my lord, already
We'll
filed.
not take out Orsona now, we'll take up Mitali first.
Mitali will.
Yes.
Archana will be filing with the leave of this court. Milord.
Now, this has to be looked into individually.
That is what.
It is
My lord.
the
My lord, may
case
come
of
to
the-
Mitali Sharma. The affidavit filed by us at page 138, paragraph 11, we have stated. And if your lordship can take up the affidavit filed by the government, my lord. Respondent number 2, which start at page 78. Our guide, Dr. Mitali Sharma's guide is from NN Sokya College, Titabar. Cannot be. Guide has to be from the same university. See page 89, Miller.
Pages are not matching.
Annexure R2, page 89.
Just a minute, we are still looking for that affidavit.
By the government, Miller. It started page 78, I suppose.
That's not. 78 struck off and
Srimati
made,
Kavi
88
Barua.
is yours.
Srimati Kavi Barua.
We find it. Yes, yes.
Got it, Miller. Annexure R2 of that affidavit. Need not to see anything else, Miller. The matter ends here. Office order. We hereby directed to approve Dr. Vishwanta Kumar Sood, lecturer, Department of Mathematics, NN Sokya College, Assam, as a research supervisor of the University for Mathematics. Singhania University cannot appoint a teacher from a college in Assam to be the research supervisor for their students in Singhania. Cannot. Because this rule says, if Lordship takes up the 2009 rules, PhD regulation, 2009, 2016.
Just a minute, Mr. Soma, we are trying to do the magic. We don't have the rules, we are trying to do magic and bring it.
I'm giving my.
Achha, you will give a copy. How do you get it if you are not giving it?
Extra copy get a copy.
What was the topic? Studies on computer-oriented numerical methods for effect of applied magnetic field on some blood flow problems. Yes, which one is it? Yes, we have it. Where does it say?
Finally, para 6, we have to read para 6 and 7 together. These are conjunctive. These two clauses are conjunctive. If I may read. All universities, institutions deemed to be universities and colleges, institutions of national importance shall lay down the criteria for the faculty to be recognized as research supervisor both for MPhil and PhD programs. All universities, institutions deemed to be universities and colleges, institutions of national importance shall lay down and decide that on annual basis that a predetermined and manageable number of MPhil and doctoral students depending on the number of the available eligible faculty supervisors. A supervisor shall not have at any given point of time more than 8 PhD students or 5 MPhil PhD students. Means not
It has to be a faculty member.
faculty member from the same university or constituent colleges of an university or affiliated colleges of a state university. Because private university cannot affiliate colleges.
And in any case, this letter shows that it is not from an affiliated college, it is from some other college.
Out of the state even, not even within the state. Singhania University, presuming it for a moment a regular university, private university, but valid, presume it for a moment. To my information, it is not a recognized university. Presume it for a moment, it is a recognized university. Since it is a private university,
Not beyond the state.
Not beyond the state, and it cannot affiliate any college. It may have its own constituent colleges. It may have its constituent college under the university itself, but it cannot affiliate a different college under under the administration of different organization.
Okay.
That is the end of the matter. If her PhD degree is not regular, how can she get the benefit of that degree? That is the whole crux. Why not we to clarify? Why not we look into this once more? If I miss send it to the. This is the clarificatory notification of 2015. My news.
This has nothing to do with the PhD program. This judgment that you have given, it has nothing to do with the PhD program.
No, my lord. That is for close the directed not to enroll further.
Ah,
I showing that.
ah,
And regarding PhD,
what the Delhi High Court has held is that the UGC cannot do that once it is a state university.
Yes.
You cannot do that.
Yes.
But the validity of a PhD
On that count, I
has to be on the UGC
Yes,
minimum qualification.
I am giving to judgment, my lord, on that regarding PhD, my lord.
So you have not done it on a, you have done it on campus at
Yes, my lord.
Jhunjhunu.
Yes, my lord.
You have gone there to Jhunjhunu.
Yes, my lord.
And done it.
Yes, my lord.
Okay.
These two judgment, my lord, one from Punjab and Haryana High Court and Division Bench of Bombay High Court.
It's a statement on affidavit that he has gone to Jhunjhunu.
And their affidavit in favor us.
Affidavit of whom?
UGC as well as state government. My lord, first
What is this?
This is relating to PhD and clarificatory order of the UGC. Regarding that, I rely on that is, my lord, Punjab and Haryana High Court, my lord. I marked in top left like one. That is, my
When
lord.
did you get your PhD?
Relating to PhD.
When did you get your PhD?
I enrolled 30th of May 2009 and Mitali Sharma concluded in 2013 and clarificatory note in 15, which is not hamper or disturb my PhD. And that
This is a clarificatory notification. This is not a notification. This is a clarificatory notification to the 2009 rules. This is no, this clarificatory notification cannot be attributed to the principles of retrospective effect.
No, this is
It is not a
prospective,
clarificatory notification.
which held that the clarification and the amendment to be prospective in nature. In Jyoti Deswal, the clarification and amendment has been held to be
If it
prospective.
is an amendment, my lord, then it is always the
Jyoti
progressive.
Deswal, it has already been held. We are not arguing on it, sir. We are trying to read out what a court has held for us. It has said we would, what happened? We would, given the judgment in Jyoti Deswal, which held the clarification and amendment to be prospective in nature.
My lord, perspective, of course, but clarificatory notification, just to clarify something which has been initiated or which has been enacted and passed.
Clarification is retrospective. No issues.
That is what I'm saying.
Clarification is retrospective.
It can be retrospective.
How can it be prospective? Unless it specifically says so.
Amendment, my lord, of course, prospective. But
Yes.
When was that notification? 6/7/15. And when did you enroll?
2009, my lord.
9.
this is an interpretation. Clarification means interpretation of a particular rule.
And each and every query is clear in the judgment of Dr. Rashmi. Dr. Prerana and Rajiv Kumar Guha. And another one, Dr. Sanjay Tej Bahadur Singh. This, my lord.
So you have a PhD degree and they are not giving you the UGC skill.
Yes, my lord.
Their stand is that the PhD is an invalid PhD. Yes, Mr. Gogoi, what do you say?
In our High Court also said, if a university offers a degree, nobody can challenge except that university. That's my lord, in a
Yes.
case,
Mr. Gogoi. Yes. Yeah. Anything more? Any judgment? Yes.
yes, my lord.
The High Court
Depend-
judgment.
Judgment kata dilo?
It was already heard at length on the earlier occasion.
Yes, my lord.
We will
I have,
not
I
go
have
to
already,
it.
I have already provided that,
Our High Court judgment.
our High Court judgment, I am giving.
You are now depending upon Singhania University case of Delhi. Sanjay Tej Bahadur Singh from Mumbai
Bombay.
and Rashmi from
Punjab and Haryana.
Punjab and Haryana,
Yes,
and
sir.
this one,
And
Mostumi Sohoria.
yes, my lord. And subsequently, relating to discrimination.
A university offers a degree in exercise of the powers under section 22 of so and so. It is only the university who can declare the degree obtained to be untenable in law or may withdraw it. Once they have a
Verified.
degree, it can only be withdrawn by that university is what our
Withdrawal. We have said that this is invalid.
obtained to be untenable in law. So invalid.
Huh?
Only the university can say it is untenable in law. That is what this judgment says. I'm.
If I may go through.
Oh yes, please. So much about it. Yes, anything more?
My lord,
If you
regarding my
keep
lord,
if you keep lengthening it further, we will not be able to decide it and we'll have to release it.
my lord,
Short and sweet. Yes.
relating to reply from the university, I annexed in my affidavit, that is,
But
in
if lordship will not,
Keep it inside you. Let us hear one by one. Otherwise, we'll just jump in.
yes, notice issued by the respondent number 2 to the university on 7th February 2024. Page 105 in my affidavit in reply against the respondent number affidavit filed by respondent number 2. Page 90
Just
start,
a minute.
and
Just a minute. We need to
Annex
trace out
25.
your affidavit in reply.
Yes, my lord. Last
To
affidavit.
109. To the reply to the director.
Yes, my lord. Director sent letter to the university, and university on that query reply. Annex 26, my lord. Filed with the petition
26.
of my affidavit in of reply.
Yes, what does it say?
My lord, Annex 26, subject in response to your office letter by number so and so, 7th February 2024. With reference to the subject cited above, it is submitted that MS Mitali Sharma was registered in PhD program on 30th May 2009. Dr. Dushwanto Kumar Sood was provisionally appointed her research supervisor, for which he gave his assent on 16th June 2009. The title of for PhD research was approved 12th November 2009, and Dr. Dushwanto Kumar Sood was formally appointed the research guide on 30th.
We have read it.
My lord.
They say that since she got registered on 30th of May, the provisions of the letter or notifications
Yes,
will
ma'am.
not come into play.
Yes, madam. And on encompassing conduct.
Where is that encompass?
My lord, one another, my lord, I am giving. The degree awarded on 24th February 2013 by notification number such and such March 2013. Her all relevant letters, documents are enclosed herewith.
Yes, I think we'll have to release it from part third if you need to read it here.
No, my lord, it is
If you're reading your documents here, trying to find out.
Annexure 23, my lord. One certificate issued by the
Page
university.
number?
Page 102. In that affidavit in opposition, my lord. Reply, my lord.
121, What is it
To whom it may concern, it is issued by the Registrar of Singhania University. This is to certify that the award of degree of PhD in mathematics to Mitali Sharma, daughter of such and such, under registration number this in the session 2009-2013 is governed by the provisions of the existing rule and regulations of Singhania University, Rajasthan,
Okay.
and UGC minimum standards and procedure.
Read. We have read it.
My lord.
All of them.
And here it is clearly stated 5 points. And column 1, it is clearly stated awarded in regular mode, not distance mode.
102.
102 as per his affidavit page number, running page number is 121 in my file. Yes, anything else?
No, my lord. And if it is and similarly situated other persons also, an implicit party here, they are continuing service and enjoying.
Continue. You are also not discharged from service.
They enjoying the full-fledged UGC scale, my lord.
Okay.
This must.
Where is that list?
That list, my lord, in my writ petition, page, my lord, 8. Writ petition, page 8. Respondent 7 to 11, my lord.
Why are they parties? You won their school cut off.
They are similarly situated person. They enjoy UGC scale, but we are depriving. It is discriminating.
Anybody paying for 7 and 8 in Mitali Sharma?
It is nobody appears, but the principal of the said college is appeared.
Yes, who appears for the principal? What do you say? You said they should get it. What? In Mitali Sharma's case, what do you say? Tell us. Affidavit. You are supporting her case. Okay. Yes, Dr. Somua, we can have something from.
But this is perhaps it can be distinguished if one is the observation given.
We'll hear you on that. Mr. Gogoi.
Well, by this paragraph, the power of a civil code and the power under Article 226 can be taken. In my expectation. Well, 0 is also salary.
That is. Yes, Mr. Gogoi.
In this case, Lordship, we have filed a detailed affidavit. Here, Lordship, regarding mode of obtaining the PhD, it is the issue. Lordship has to decide whether it is as per UGC regulations or not. If it is UGC regulation, if Lordship find that the petitioners did UGC regulation, we have nothing to say. We have to give them the benefit. In our after thorough examination, it is found that it is not part of UGC's prescribed prescription. That's why that degree was not treated as a qualified degree for obtaining the UGC's required scale of credits. So that's part. So Lordship may kindly give us our affidavit. First, I go to the affidavit, then I explain the with my I cited some judgment in respect to the particular issue, then I will reply the judgment which was related to the petition. Proceed page 81 or affidavit. Page 81. Paragraph 8 onwards, if Lordship permit, I can read it, Lordship. That the deponent begs to state that, Lordship got it, page 81. This directorate further sought following documents from the College Authority in connection with the PhD degree obtained by the petitioner from Singhania University. Number one, PhD notification with regard to the awarding of the PhD degree to the petitioner. Number two, detail the petitioner's PhD guide. Accordingly, the College Authority supplied the notifications of award of degree of Doctor of PhD issued by the Singhania University in respect of the petitioner, along with the other by reference number so and so, where it is reflected the name of supervisor as Dr. Dusmanto Kumar Sudhaki. Further, the College Authority submitted the office order reference dated so and so issued by the academic inserts, whereby the University Authority approved Dr. Dusmant Kumar Sud, lecturer, Department of Mathematics of NN Sokia College in Titapur, Assam as a research supervisor. That part is Lordship Annexer 1 and 2. So Lordship, my lord may kindly come to page 88, Lordship. Page number 88, Lordship.
88, but those documents
This is a notification issued by the Singhania University, where petitioner's name is reflected in CL number 7, Lordship. Then in column number 4, Lordship, name of the supervisor, it is Dusman Kumar Sud, Lordship. Then my lord may kindly come to next page, Lordship. It's an office order issued by the academic registrar of that particular university, Lordship, where it is reflected that Mr. Subensu was appointed as the research supervisor for the University of Mathematics. He is from the NN Sokia College, Titapur, Lordship. Then my lord may kindly come to paragraph 9 and 10. 9 we have explained regarding the appointment of the supervisor, Lordship. And 10. That the deponent begs to state that from the above notification dated so and so, it is discernible that supervisor for obtaining the PhD degree of the petitioner was Dr. Dusman Kumar Sud, who is the lecturer, Department of Mathematics, NN Sokia College, Titapur in the district of Gauhati. The appointment of Dr. Dusman Kumar Sud as a supervisor PhD guide of Mitali Soma by the Singhania University was invalid and contrary to the University's Grants Commission's minimum standards and procedure for awards of MPhil PhD degree regulation 2009, which is before Lordship. And paragraph 11, Lordship, for a convenience of my lord, we have quoted the relevant provisions of the UGC's notification. That's the read of Lordship.
I have seen that.
Lordship. So Lordship, basic issue and paragraph 12 also we have reiterated, Lordship, that verificatory part, Lordship. Then Lordship, paragraph 14, page 85. That the deponent may read it, Lordship. The deponent begs to state that from the above, as per the UGC's regulations, so and so, only regular faculty can be appointed as the research supervisor, guided by the university, not hiring a supervisor, service of supervisors, and not adjunct faculty, Lordship. Petitioner Mitali Soma, supervisor of PhD, Dr. Dusman Kumar Sud is a serving lecturer, Department of Mathematics, NN Sokia College, Titapur, in the district of Gauhati, Assam is not an affiliated PG college / institute under the Singhania University, and the said college is not within the area of territorial jurisdiction of the Singhania University, and Dr. So-and-so is not a regular teacher and faculty of Singhania University. The Singhania University is circumventing the provisions of UGC's regulation 2009 by utilizing / appointing Dr. So-and-so as research supervisor of petitioner so-and-so. Therefore, the PhD degree obtained by the petitioner under the supervision of so-and-so, which is not in conformity of the UGC's regulation so-and-so, cannot be accepted as a valid as per UGC's regulation so and so. If we accept this kind of, it is with tantamount and diluting the provisions of UGC's regulation 2009, and it will be rendered up provisions of the individual lawsuit. So, lordship, on the basis of that particular degree, lordship, that particular degree was obtained by the petitioner under the guideship and who is not a faculty of that particular university, lordship. That degree cannot be treated as a lordship if we obtain as per the required prescription prescribed by the UGC, and that's why, lordship, on the basis of that degree, lordship, the authority did not confer him the UGC scale of pay, lordship. This is the stand taken by the Higher Education Department. And if we go by the provisions of the UGC regulation before, lordship, the UGC's regulation very specific, lordship. It
Can we go like this, Mr. Gogoi?
lordship,
He is claiming a PhD degree
lordship,
to get the benefit of the UGC scale of pay. UGC scale of pay would be applicable to him if he is qualified as per the UGC regulations. UGC is saying that we are not recognizing this PhD. Therefore, as per UGC, he does not have the PhD.
lordship.
Therefore, the question of him getting the salary does not arise. The scale does not arise.
It is the issue, lordship. Otherwise, if we go by the prescription prescribed by the UGC, lordship, the rewarding of the PhD degree, lordship, we cannot dilute it. Even that particular university also cannot dilute it, lordship. And I will place the judgment in this respect. Before that, lordship, just the judgment relied by the lordship, that particular judgment, Jyoti ne ki Gujarat, Punjab to different Punjab.
Jyoti Deswal,
Jyoti Deswal.
High Court, Delhi High Court.
Punjab,
Punjab
Haryana.
and Haryana, yes.
Dr. Rosmi, where that particular clarificatory order was discussed, lordship. The Honorable Punjab and Haryana High Court says that it should be prospective, lordship. That will not apply in the case of the petitioner, lordship. This is the findings.
Clarification, clarificatory is retrospective unless
Clarificatory order is always retrospective, lordship. Unless it is said that it should be from the effect of so and so date, lordship. I will place the Honorable Supreme Court judgment in that particular part, lordship. Then Marlin judgment is there. University of Kerala and others versus Marlin Jain, lordship. It is in respect of
Shelly products. Yes, no, I was trying to remember that Shelly products name.
lordship. It
Para
is
23, na?
Para 23, lordship. When an enactment or an amendment is a declaratory, curative, or clarificatory, implied by a PAL that need not to make clear what was always intended. Such amendment is
Usually meant to operate from an antecedent date or to
antecedent date or to cover the antecedent events. This position was clarified by the Commissioner of Income Tax versus Shelly products that just now my lord have indicated. It seeks to clarify the law so as to remove doubts leading to the courts giving conflicting decision, and in several cases directing the revenue to refund the entire amount to the income tax paid so and so. Being clarificatory in nature, it must be held to be retrospective.
This clarificatory is this 6th of July 2015.
Even, lordship, we not go by the clarificatory orders also, lordship. There is no ambiguity, lordship. Very specific. I am not relying the clarificatory order, lordship. I am just relying the prescription prescribed in 2009 regulation. It is enough. If the petitioner places that the clarificatory order part in the Honorable Haryana High Court, Rosmi's cases, lordship, then also, lordship, it should be retrospective, lordship. We go by the law laid down by the dictum given by the Honorable Apex Court, not by the lordship, Honorable High Court, lordship. So, lordship, paragraph 24. Likewise, in Jail Singh versus State of Haryana, this court quoted from GP Singh's Principles of Statutory Interpretation, 9th edition, and applied the relevant rules for construction, lordship. Paragraph 24, lordship. If a new act is explained, an earlier act it would be without object unless constitute retrospective and explanatory act is generally passed to supply an obvious omission or to clear up doubt as to the meaning of the previous act. It is well settled that if a statute is a curative or merely declaratory of the previous law, retrospective operation is generally intended, an amendment act may be. Yes. So, Lordship, if we go by the Lordship that clarificatory or declaratory circular issued by the UGC, then also it is as per the dicta given by the Honorable Apex Court. It is a retrospective operation, Lordship. If we not for a moment, Lordship, we are not relying that particular two document, then also my Lord may kindly come to the UGC's regulation 2009. Once again, Lordship.
In the UGC regulations, in any of the UGC regulations, is the word faculty
Yes,
defined?
faculty was that particular 2009 regulation. That particular issue was came up before the Honorable Kerala High Court. Faculty was discussed who should be the faculty. I am relying that, Lordship. Before that, Lordship, my Lord may kindly peruse.
We'll get an answer to that question. If the faculty has been held to be someone
Lordship.
who
Even
should be
Lordship,
within the institute itself,
Lordship.
then this faculty is clarified.
Lordship, faculty is a recognized research supervisor. That part very specific. There is no ambiguity. There is no doubt, Lordship. Two judgments I am relying, Lordship. One from Honorable Kerala High Court and another one from the Honorable Rajasthan High Court, Lordship. Lordship, I am relying Honorable Kerala High Court judgment, paragraph 3, 10, 11, 18 and 22, Lordship. In Lordship permit, I can read it, Lordship.
We can read 11 and 3, 10, 11 and
3, 10, 11, Lordship, 18 and 22.
18.
If Lordship directly go to the that one which was
Otherwise, if anybody from any of the university could have been taken into taken for a research scholar, then they would have said any qualified teaching.
So particular Lordship query was Lordship
What is
decided in paragraph 18, Lordship. Directly come to that.
I read it.
The meaning of the word faculty as available in the Oxford Advanced Learners Dictionary is all the teachers of a particular university or a college, Lordship. In Merriam-Webster Advanced Learners Dictionary, faculty means the group of teachers in a school. In P. Ramannatha Iyer's Advanced Dictionary of Lexicon, faculty is defined as a faculty, means a faculty of the university, Lordship. And faculty means the faculty of the central education institution and department of the learning at a university.
It has to be within the institution.
Within that particular institution. That exactly that issue was arises before Honorable Kerala High Court. That's why this has come. And then Honorable Rajasthan High Court, Lordship. Yes, Rajasthan to Imam Kaviyasin, no? Honorable Rajasthan High Court, I have to read the whole judgment, Lordship. Everything is discussed. That particular issue was arises, Lordship. Exactly that point, Lordship. From paragraph 1 onwards, Lordship. Paragraph 1 onwards, it was discussed, Lordship.
Yes,
If Lordship, I can read it.
I'm just trying to go through.
Lordship.
This was more, this was with regard to the 2016
Lordship.
regulations.
Lordship.
And whatever has come in 16, 2009 was sought to be clarified by 2015.
Lordship.
So therefore, the case of the state is that whatever is in 16 has been clarified by this Rajasthan High Court. And if the regulations are read with the clarification of 2015, 2009 regulations with 2015 clarification, the situation remains the same because it was not a faculty from the same. Therefore, the PhD cannot be held to be the same, and therefore, her claim for salary at the UGC scale,
UGC scale, and was the abroad Lordship appointment, which was clarification, which was the Lordship clearance sought from the state of Rajasthan was declined by the state of Rajasthan. That particular case, that particular petitioners get an opportunity to the abroad in the one American university Lordship. He had sought some Lordship, that Lordship clarification part is there Lordship. He had to, that part was also declined by the state authority Lordship.
The government took a view that the petitioner's PhD degree could not be authenticated by the department because his PhD guide was not a regular faculty member. Similar is the situation for you.
It is a similar situation for us, Lordship. And Lordship, that particular even Lordship, one of our High Court division bench of the division bench also discussed in that particular point, Lordship. But not exactly the same issue. The issue was that appointment of the principal, Lordship. Appointment of the principal, there was a condition that Manipur Public Service Commission has better. Paragraph 26 is sufficient, Lordship. Paragraph 26, Lordship. They are the guides from the Lordship. The particular persons are guide from the CMJ University, and that guide was not treated as a valid guide. That's why their appointment made by the Manipur Public Service Commission was also set aside, Lordship. They have not fulfilled the required guideship, Lordship. My Lord, made paragraph 26.
Then how this university is giving that particular certificate regular mode?
They can, Lordship. There is no issue that regarding granting of PhD, Lordship. Lordship has already gone through that chapter, Lordship. Even Lordship, after registering the PhD in Bodh Gaya University, within a period of 13 days, they have got the PhD. This is the example. Within a period of 13 days, after registration of the PhD in the Bodh Gaya University, within a period of 13 days, they have got the PhD degree, Lordship. Mr. Somay is well aware of that part, Lordship. Within a period of 13 days, one of the gentlemen from the Lordship.
It would take more than 13 days to print the thesis if I'm without
in a period of
typographical error.
One of the gentlemen from the Lancashire College, Lordship, he has got the PhD degree, Lordship. Now he is under and another 6
this para 26 that you had referred to,
Lordship,
in this Gauhati High Court judgment,
Lordship,
this is the ground raised by the petitioners.
Lordship.
How was it answered?
Then, my Lord, page 32, Lordship, paragraph 32, last portion, Lordship, and next page, Lordship, paragraph 32, it is a Lordship, 32, last part, even of that part, my Lord, got it. Then 36, my lord, may kindly come, paragraph 36.
In this case, the private respondents were saying that we have the
Research guide from
the experience. We have the experience because our PhD students, our scholars are from some other university, but we have guided them. We have got the experience. High Court said no.
No, that's
You do not have any experience while guiding them because you are from here and they are from there. That is what.
That is. Paragraph 36.
Sum and substance is that.
Sum and substance is that, Lordship. So, Lordship, this is my submission.
Okay.
Yes, because, Lordship, the PhD obtained by the petitioner is not the prescription prescribed by the UGC's regulations. That's why, Lordship, he is not entitled for UGC's required pay scale, Lordship. That is our summary. That's why he is getting the fixed pay, Lordship. As and when he is obtained the PhD, net or MPhil, Lordship, he will be always welcome and we will give him the full UGC scale of pay, Lordship.
But due to official procedures, sanction may take the time, but you, of course, afford him the.
Otherwise, one question was also raised by my senior lordship regarding that some persons have given lordship.
Yes.
It is an admitted fact some persons has given lordship. And those persons has given lordship, some of the cases is also pending here lordship. And we have also.
In any case, if we hold that.
We have also take action against him lordship.
If we hold that he is not entitled to, it was not proper to have given to anybody, then this will be negative equality.
That part I am relying.
Someone got it wrong, therefore why should you
that part I am relying 2022 SCC online, SC 151 lordship.
Yes.
Paragraph 28 lordship. A principle axiomatic in this country's constitutional law is that there is no negative equality. In other words, if there has been a benefit or advantage conferred.
Understood.
Lordship. I am relying that particular judgment.
Okay.
This is my submission before. Oblige, Lordship. Other two cases are similar. Even Lordship, one of the cases, Lordship, my senior brother has bring the records, Lordship. That Tilak Soma case.
What does it say?
The record. Our argument will be similar. Record reflects that lordship is on duty even the awarding the PhD exam was.
When the exam was going on, he was on duty. He was totally on duty. He was doing classes. This other WPC number 4721 is at a better footing because he says that no adequate leave was taken.
Even adequate leave, lordship, even he has granted the full leave also, lordship. Then also his PhD cannot be treated at par with the UGC's regulation 2009, lordship. Here issue is not whether he is taking the leave or not, lordship. Here issue is totally defined. Here issue is that.
No, that issue came up because when he said that it was regular.
Lordship. No,
whether it was distance mode or regular mode, we thought that there will be some relation between leave and the.
Even lordship, even lordship, my lordship find that his PhD degree was the regular mode PhD degree.
Okay.
Then also lordship, he is not as per the prescription prescribed by the UGC, lordship.
Okay, Dr. Chamwa. I'll come back. I'll come back. Dr. Somua, can we retain this for
Yes.
I have supplied.
This is not part of the thesis.
No, this is
not part of his thesis, lordship.
His thesis.
This is not from the zero salary part.
Achha. It has come from there.
And here it is distinguishable. Because of the fact that this is a IA, my lord. IA's order is an interim order.
No, the petitions were disposed of on that line. This, I think, had gone up in appeal, was upheld. And so far as we recall, there were certain matters where this, now the department has also, in one of the matters, we were given an instruction that this thing will be accepted. Because the only case, in their case, the only thing was that it was by, they could not have done it because this degree, that B.Ed degree was given by some university, say Nagaland University.
Yes.
And they were shown on record here all the time. They were denied that promotional benefit. saying that the B.Ed degree they could not have attained. This court finally came to a conclusion that once the degree is validly given, following the norms, whatever are there, and the university says that yes, it is valid, then others cannot question it.
For
This-
that, the university has to be valid. And the degree has to be, the sine qua non is that it has to, the university has to follow the procedure established by law. Here, Lordship has seen that the faculty guide is
The
not,
thing
is
is,
out.
in this case, the B.Ed degree was to be given in a certain manner by attending regular classes and all. University had given all the attendances, university had given everything. They were shown present there. The
That
degree
is
was
fully
given.
procedural prescribed.
On record,
Compliant.
everything was correct.
Yes.
In your particular case, it is your argument that the guide not being according to the UGC regulations,
Yes.
the PhD cannot be valid.
Yes.
And this is what the UGC is saying. It will be similar if in this case, the NCTA have come up to say that the degree is not. This is a case where the appointing authority had questioned the B.Ed, not the NCTE. But in this particular case, the UGC is
Asking
opposing it.
Opposing, yes.
In that case, NCT was not opposing it.
So that is a distinguishable factor, Miller. And in this case itself, even.
It is this decision we are drawing only because we will have to answer questions.
My lord.
Not
So
that we are
what
making
has
comments.
fallen from your lordship, my lord, is this, that the degree was provided by the university following all in compliance of all the procedures and rules. That is why once the degree is given validly, that cannot be questioned by others. In this particular case,
Whether the
degree was not given validly.
My submission is this, my lord.
Yes.
University issued certificate validly.
Hmm.
And what is the basis? They said that that university is not valid. Without any, if it is going through the list of universities all over the India, that is, it is very clear that that university is also in the list of universities of India. My lord. And now, without any document that that university
That part we have understood, that part of your argument. When you say that a university is authorized by law to give a certain degree, that university has given me a degree.
Yes.
Once I have the degree,
Yes.
you are no one to question it. Is it not?
Yes, ma'am.
It is only that university will say if it is fake, forged, whatever it is,
Yes.
the university will say, not any other person.
Yes, my lord.
And their case is, university has the authority to give a valid degree,
Yes, my lord.
provided it is valid. You may have a degree given by that particular university, but since that degree was not given in the manner provided for by the UGC regulations,
Yes, my lord.
you will not be entitled to the pay scale
Yes, my lord.
given by the UGC regulation. This is the case?
Yes, my lord.
Our
And,
judgment will
regarding, my lord, power of UGC, Division Bench of Bombay High Court, it is stated in para 8 of my judgment, which I provided.
Bombay High Court.
Bombay High Court. Bombay Civil Appellate Jurisdiction, it is Dr. Sanjay Tej Bahadur Singh.
Where do we have Sanjay?
Paragraph
Tej
8,
Bahadur
my
Singh? Yes, Sanjay
It
Tej
is
Bahadur
stated.
Singh. Para?
8.
8.
Page, my lord, 6.
Yes, it is a submission of the learned council.
Yes. And council submit that UGC has limited power.
Two things, sir, we are wasting time. First of all, Bombay High Court would be what? Persuasive. Number two, of a persuasive judgment, you are referring to the submissions made. Why should you read it?
And my lord,
Icing on the cake.
Cherry on the top.
Give us something we can rely upon, refer to, we are bound by.
and my lord, regarding retrospective, my lord,
Retrospectivity.
my lord,
Omorshil,
one judgment is
that advertisement, clarification, it would be allowed.
Review.
Jyoti
Yes,
Jashwal.
review.
That is one,
Jyoti-
that
Jyoti-
is one batch. Another batch is by Justice Barua. Retrospectivity was discussed.
Jyoti Jashwal, my lord, right?
Huh?
Jyoti
Jyoti
Jashwal, it is Jyoti
Jyotish?
Jashwal versus
Jyoti
University
Jashwal.
Grants Commission.
Jyoti Singh.
Jyoti
That is
Jashwal.
by another
Jashwal.
high court. That is
Jyoti
by another high
Jashwal.
court.
It is, my lord, Panjab
is-
Haryana High Court.
Huh?
I am giving this. High.
was replied by the
Jyoti,
It was replied by the in the Marlin case by the Honorable Appeals Court.
Jyoti Deswal, it was held that this clarification has come in 2015.
Yes.
So if it was not followed in 2000, from 9 to
Nine.
2000, 2015, it was not followed,
Yes.
then those people would not lose the validity. They should be accepted for all purposes. And after 2015, when the clarification came and thereafter the 2016 regulations came, thereafter one should be.
Yes. Yes, ma'am.
That is your argument?
Yes, ma'am.
Okay.
And that is there.
Okay. Now the attendance.
My lord.
You are appearing in all the matters?
Yes, my lord.
Other matters, anything else to argue?
Similar matter, my lord.
It will cover.
And,
We can record in
in-
the top of the order that all the matters, all the petitioners being similarly situated.
Yes, ma'am.
Mr. Ahmed has put in the arguments for all the matters in these lines.
Yes, my lord.
Heard
And-
Mr. K.U. Ahmed, learned counsel for the petitioner in WPC in all the writ petitions, full stop. You have some submission to make, Dr. Agarwal? Oh, I'm so sorry. Please. That is only a difference, but otherwise the point that requires the decision is. And the arguments of Mr. Dr. Chomwa. Judgments of Mr. Gogoi and arguments of some.
Yes, because two doctorate is here for the your PCC lordship, one doctorate representing two cases and one doctorate representing lordship one cases. Only
And they are relying upon a non-doctorate.
Non-doctorate.
lordship has to just record their name. In
Huh?
two cases, Dr. Somwa and one cases
I hope we would not require a doctor after this.
lordship. And she was recently appointed as a guide. So
He has the experience of being under a guide, and she would soon have the experience of being a guide.
Being a
Good
guide.
enough. But that will not affect the merit of the case.
lordship.
Okay. Your personal experiences will not be taken into account here. Heard Mr. K.U. Ahmed, learned counsel appearing for the petitioners in all the writ petitions. Mr. Dr. A. Somwa appears for the UGC in WBC number
4721.
and 6543.
Yes, 6543.
Dr. Mr. K. Gogoi appears for the
All the
Department of Higher Education
in all the cases.
in all the matters. Dr. P. Agarwal appears for the UGC in WPC number. Mr. So-and-so appears for respondent number
In WBC 47.
and respondent number 3. Got it? Arguments heard, judgment reserved.
Duly obliged.
Obliged.
But this will take some time. Don't expect it too soon.
My lord, we have no hurry.
And he might be. 2021. What is this matter, sir?
May I please, sir?
Huh?
Method compaction at the matter.
What to do, sir?
Lordship, I want judgment of singleton also, Lordship.
Yes.
Paragraph 9, my lord. There is a direction, Lordship, to the district level committee and state level committee, Lordship, to Lordship, consider, Lordship.
Where is the government?
Which are pending, Lordship, before this court, all cases.
After some time, let the government. So your matter was pending on that day.
Lordship,
So it will be,
yes,
it will have to be reconsidered.
Lordship,
That is what the division bench has also said.
yes.
That is what we were asking you. If it was pending on the date, writ petitions, you would get a reconciliation. If it is not pending on that date, if it is filed after. Yes, next to Matagato after some time. The,
Covered matter, my lord.
cover?
And matter relates to.
No, that one where you had to give that, take a new lease. Is this the one?
Yes, yes.
The new lease.
That
What to do?
I have already stated that it's not a covered.
So we'll take it up for hearing then,
Not-
finally. Anna?
may I start?
Not today, sir. Not today. By the order. No, this kept, the matter was heard at length on 2/2/2025. The matter was again heard on 9/12/2025. When the matter was fixed in the month of January for further hearing. It was listed on 28/1/2026 when the matter could not be taken up. Today the matter is again listed before this court.
Thursday, man.
That is why we had to note down that we cannot keep it more than a month. List this matter again, on give a hearing day in March. Tenth of March. 10th of March, matter shall not be treated as part heard.
Can
One or
it be
two-
after 12 or before?
Any day, you choose a date.
After 12, my lord.
After 17th of March?
17th.
17th of March.
Deep law.
Yes.
19.
We already received the copy, my lord, affidavit approach.
So now what to do? You want to file reply? The learned counsel for the petitioner has sought for an accommodation to file the affidavit in reply. List again on 25th of March.
Alright.
Make this Lordship, today morning I have filed an additional affidavit, Lordship, as per order dated 27/1/2026. But document is not with the record, Lordship. Can it be taken any other date, Lordship? Not take.
It has been submitted by the learned counsel appearing for the respondents that an additional affidavit as required by this court in the earlier order has been filed today. The same is not on record. List again on 23rd of March.
Lordship, can it be first week of March, Lordship?
You have some urgency.
Lordship.
2nd of March. 2nd of March.
Or 23rd of March. Lordship.
I was giving 23rd of March.
Lordship, I assume it's the 23rd February. February, I had some problem. Lordship, I wrongly heard. 23rd.
It is 2/3/3, 23rd March.
High level.
21 to 23.
2024. Yes, what does the director say?
No, the director of this, the information which was sought from the finance department was earlier also given, my lord. With regard to the financial implication, the this.
The financial implication, what I have seen is.
Kindly have the first requirement by the secretary.
Yes.
What is it?
My lord, that for that.
Total number of posts.
Yes, for that. my
And
lord,
what is this? It does not have that number.
Yes, this is the secretary is the new letter, my lord. As per my verbal instruction, my lord. They have sought for a report from the inspector with regard to the post. From the inspectors, my lord.
They are still asking for it.
My lord, yes.
So the department as of today does not know how many part-time vocational teachers are there. They are being paid some salary.
They're not
Are they
part-time, they're not part-time even, but then
They
their
are being
scale is
paid some,
wrong.
they are paying some salary, not
Yes.
equivalent to the part-time, but they are being paid some salary. Who are being paid salary? Your department does not know.
But a report has been called for the inspectors, my lord. The concerns.
All these years, there is no count of the number of teachers. When can you give us the number of teachers? When can the inspectors of Assam of independent India can come up with it?
But maybe next week, my lord.
Take some more time. Have it on the 5th of March, 6th of March.
5th March.
Give us the number.
6th of March.
Eh?
6th of March.
Mr.
5th, my lord, is a Thursday, my lord, would be better. We
But
can
then
make an effort, my lord.
No, if he does not bring the number of teachers, then our 6th matters, one slot is done.
Number is reflected in many of their correspondences. I think it is around 147. They are the left out person.
158 teachers permit
sorry, 150.
equalization with those of 274 regular vocational teachers.
That number
Why
is
not
there.
a specific sentence at the top of the instruction?
That
That
itself
there
gives the
are
number.
158 teachers and there are 274 regular vocational teachers. The instruction dated 4/2/2026 produced by Mr. B. Kaushik, Learned Counsel, looking for the Department of School Education, says that reflects that the Finance Department has asked for clarification regarding total exact number of vocational part-time teachers, total financial implication and budgetary provision provided for in 25-26. I think you should wait for April. 25-26 will be finished in March. They are still asking for March budgetary provision.
Then they will ask for the next
The-
year's budget.
We can have it in April perhaps. You'll have a better.
My lord, if the legal issue is decided otherwise, that whether we are
Entitled
entitled
to-
to at par salary, my lord, with the others, then other consequences may follow.
The report sent by the director does not reflect particularly as to the number of, as to the total exact number of vocational part-time teachers required for equalization of pay. Stuff. The instruction, the letter from the Director of Secondary Education, however, reflects that as on basis of the availability of data qualification of some teachers in respect of 158 teachers, permit equalization with those of 274 regular vocational teacher, full stop. Can you make out the meaning of this sentence? Mr. Kaushik would have his instructions as to when the clarification and views required by the Finance Department would be appropriately addressed to by the Director of Secondary Education and the Secretary of the Government of Assam, Department of School Education, full stop. It is made clear that in the event, that on the next date fixed, this court may take up this matter for final disposal on the basis of the pleadings on record to determine the eligibility of the petitioners. As prayed for in the petition, full stop. Place this matter again on 31st of March. It's a hearing day. The budget 25-26 they have called for. It is not going to work for you. Is it?
We'll
Even if
do
they
it in
send
the
all
next
the details,
financial
will
year.
something come up? Nothing. Give it a flash in 26-27. By that time we'll decide. It was directed to be listed for further hearing before a
Yeah.
particular court. I think it should go
Yes,
before
sir.
that.
Lordship, if that is followed, Lordship, I had made a submission to the honorable court on the date of hearing that it should be made further, but he has not agreed to make further.
In view of the above, list this matter for further hearing.
Lordship, that is.
Hearing the matter at some length.
Lordship, I understand. But only thing is, Lordship, I have made a request to the honorable court after arguing the case to list the, make the order further matter. But he has said no, no.
It will be like asking someone to write Mr. when
Yes,
we are
sir.
referring to it to him as he. Means the same.
That will be listed.
The order dated 3/2/2026 reflects that the matter had been heard at some length and was directed to be listed for further hearing by a coordinate bench, full stop, registry to place the matter before the appropriate bench. It brings about a difference in views at times. So, if it is released, you don't have any defeat.
It's a matter of gratuity, Lordship. That is why, Lordship, it was heard by 3-4 judges. Twice, thrice, they have taken time. And we have agreed all the times. Not only by this honorable, that honorable court.
But it says non-payment of salary.
Gratuity and area salary. They have retired in 2023. And they are receiving minimum pension of rupees 3,000 and odd from Provident Fund, not their government employee.
We understand, sir. You must appreciate we have endeavored to take up every matter. Once we find that it is
Only
further
Lordship,
hearing,
next week, Lordship. Lordship will fix the next week. In the
when we
court is available, Lordship.
when we say that list before the appropriate bench, we have been told it was listed the next day when the bench was available. Immediately on the next day, it was brought on supplementary.
Generally, Lordship, registry do not do it. That is my experience.
Everywhere there is some pain. All cannot be expected to
Because
be.
I have to take the pain from my client.
If we speak of a date and that on that date,
The
the
court is
bench is
available,
not.
Lordship.
Can we say so in an order? Can we direct it to be listed before us?
No, Lordship is directed to appropriate court. So if available next week. I understand everything, Lordship. Not date. I'm not fixing for date, Lordship. If available next week, Lordship.
Yes, Lordship, we have filed our affidavit, Lordship.
Last occasion, morning they informed me that they will take time for filing their
The
reply.
affidavit in opposition filed by the respondent number 1 to 5 is on record. None appears for the petitioner on call. List this matter in April. What is the matter about?
Lordship, their promotion, Lordship.
Promotion.
Already the petitioner's case was placed under seal cover, Lordship. Criminal case is going on, Lordship.
List this matter again on 30th of April 2026, by which time the petitioners may file their reply.
Hello.
Please appeal.
Supplementary item 46 to 45.
May I please your lordship? I am appearing on item number 48 and 50, my lord. These are the original cases. Thereafter, those cases are added with this.
My lord, in 50, my lord, we preferred an IA for impediment of the.
My lord, what happened? My lord, kindly see the last order of the item 48 and 50, my lord. On 9/12/2025, it was attempt, my lord, the pleadings was complete long back in the month of September, my lord, and it was attempted to be disposed of. On that day, my lord, the special request, my lord, that they are filing an IA, the government side, my lord. So they are filing on the same day. They have filed also, my lord, but it is still in defective stage and it is not getting listed, my lord, since then, my lord. Since 9.
Or what is the IA?
IA there for on maintainability. They served the copy on us on 11/12.
Huh?
They served the copy also on us on 11/12, my lord. But it is yet not been registered or perhaps not listed also, my lord. Only to delay the matter.
It was
Yes,
in,
why do you say that it is not maintainable?
Lordship, actually, our senior government advocate, he is appearing lordship. So he is on legs, he will be coming lordship.
Milord, kindly item number 52, kindly last order, Milord. Item
You
52,
tell me
kindly
the
see the
item
last
number
order.
को आपने item number में कर दिया। मैं 52.
52.
Yeah, 52 do.
Kindly see the last order. Long order this. Deputy.
It was modification.
So do you mean to say that there is no select list at all? People have been appointed.
Milord, what happened in this case, Milord?
There was one more matter, madam, I think, where we were,
Yes, lordship.
where we had required that the records to be produced. And if the person, if the records are not available, the person concerned who maintains the record to be produced, to be present.
Lordship, kindly take it up after
Yes,
some
yes.
time, lordship.
Because-
It's coming, lordship.
Because when we are saying that
Yes, Lordship.
there is no select list,
Yes, lord.
I have filed.
200 posts were required to be kept vacant.
Yes,
In
their
our
order is there, lordship, yes.
So tell us, how many writ petitioners are there in your case?
My case, Milord.
This
And
is
one by one,
yes,
we are,
paid for 25, lordship, yes.
we are at item number 52. How many petitioners?
6, Milord.
6. What do they belong to? They all belong to the OBC category.
And no, my general category.
We'll dismiss it. We will dismiss it. An OBC category person may have it in, make it in the select list, and there will be an unreserved category candidate who will not make it to the select list. You want us to divide the petitioners one by one? Is it possible for this court? Do they have a similar cause of action? Would they be in the same merit list? Do they have a joint cause of action? Tell us. You are seeking appointment, more marks, better marks than the others. I should be there in the merit list, select list. Is it not?
My case is, Milord, the.
Publish the select list.
My case is, Milord, they did not provide the marks which I
Very good.
obtained in the case.
Very good. Now we will simply ask them to tell you the marks. Will that help you in any manner?
Milord,
How will it help you? If you
and-
become an RTI office, how will it help you?
and my lord, in this case, Milord, the respondent also did not
Do
provide
one
the
thing.
marks.
Listen to us. Do one thing. What is your prayer?
Yes. Page 14.
You see, the OBC persons are here and the general persons are here. Unreserved category and the OBC category. That is what we have seen from the table you have given, is it? At page 10? Is
Yes,
it?
there is also OBC category, Milord.
There are OBC category candidates and there are unreserved category candidates.
Three are the OBC and other 3 is the general.
Unreserved category. You are asking for respondents to comply with the upper limit of reservation quota of posts as settled by law. In that case, the OBC list may suffer. Is there not a clash of interest between the two petitioners? A probability? It is better if you file it category wise. When they come up with the merit list or when we decide the matter ultimately, we can go Read petition wise. No one will clash with no one. Withdraw the names of the 4 or 3 unreserved category. File afresh for them. Withdraw with the liberty. We can grant relief. Number 1. Number 2, what is the court fee paid?
Jointly.
Jointly. So you have to pay individual court fee per petitioner, because everybody will either get a appointment or will be rejected. Is it not? So for whom is the court fee being paid? For whom can I give the relief? You'll have to choose.
I may be allowed to amend that.
Is it not? It is not a matter of amending. Withdraw for the 3 with the liberty to approach afresh with afresh. You don't have an interim order, do you?
Yes, no.
There is no interim order here.
Yes.
Withdraw for the unreserved category with the liberty, file afresh.
That may not,
Ah.
4, 5 and 6.
Ah. Therefore, nothing much will happen today. File it, get it listed along with this. We can give judgments on the ST category, SC category, OBC category, unreserved category. Is it not?
For us.
Someone in the OBC category will jump to the unreserved category, another person in the OBC category will come in. But this kind of writ petitions, how will we decide? 1 and 3 makes it, 5 and 6 do not. Then what do we do? We'll have to sit down, categorize, make tables, give judgments. The similarity in the, we'll have to decide and come back. Take a call from your clients and come back over.
Yes.
Is it not?
Yes.
This, take down in item number 52. Mr. So-and-so counsel appears for the petitioners. It is noticed that the petitioners have, the writ petition is revolving around a particular selection process. The petitioners belong to different categories of candidates, namely, the first 3 petitioners belong to the OBC category and the last 3 belong to the unreserved category, full stop. In view of the prayers made, which also have a reference to the reservation policy followed during the selection proceeding, comma, the learned counsel for the petitioner has sought for a liberty to be permitted to withdraw the names of the petitioner number
456.
456 from the present writ petition with the liberty to file a fresh writ petition since they belong to one and the same category, that is the unreserved category of candidates. Full stop. It has been submitted that this would facilitate the adjudication of the issues in the writ petition. Full stop. Liberty as paid for is granted. Amended cause title, deleting the name of the petition number 3, 4, 5, and 6 be filed within a period of 1 week. Petitioner would be at liberty to file. Another, the respondent number 4, 5, and 6 are allowed to withdraw from this present writ petition with the liberty to file a fresh writ petition on the same cause of action. Okay. It will date the list again on date to Nidibo. What about item number 46? Who is in 46?
For the 46.
What kind of
46 and 55 are same, Your Lordship. 45, 46 and 55, both are same item.
No, we
Same-
are
same
asking,
issue.
have you heard the discussion? We
Let-
don't want to repeat it. We find one
46.
OBC category candidate, we find another
all the
OBC,
candidates-
then we have ST category candidate, then we have general category candidate, all mixed up.
Here, Lordship, all the candidates completed written, medical,
Yes,
and I have orally, Your Lordship.
When
Oral
would
list is
Mr.
not
Nath be
completed.
here?
Impune is, Lordship, last page, Your Lordship. Here, page number 135, Your Lordship, 34, 35. My case is a little different from others.
what kind of a difference, sir?
Here, Viva is not published, Your Lordship, page number 135, Your Lordship.
Learned
Not
counsel
mark
for the-
published, Your
Learned
Lordship.
counsel for the
Only-
petitioner has submitted that these cases are not similar with the other cases. Item
Not
number
only other, your lordship.
46, 47, and 48 are not similar with the other cases. That is what you're saying.
No, no, lordship, similar with some other, not fully otherwise, but in my case, your lordship, final stage.
Now
your
we
lordship.
were on another topic. We'll have to explain again. Your writ petitioners contain a mixture of different type of candidates.
Lordship.
If we allow it for one sort of candidates, it may affect the interests of the other category of candidates when the select lists are prepared.
Lordship, then my case may kindly be separated, your lordship. Only two items, your lordship.
Item
55,
46 and 45 and
46 and 55.
50, 46 and 55.
55.
Now the counsel for the petitioners that these matters may be separated from the other cases.
In-
Have
Yes,
you
item-
understood our suggestion? No.
Yes, sir.
You have not understood what we have said. Your writ petition contains different kind of candidates, all mixed up together.
Issue.
Okay. When do you want? Have you filed the affidavit? Sir, why no affidavit?
Not submitted yet, petition.
46 and 55?
We are awaiting the instruction. In fact, lordship may.
In another case, if we are not wrong, we have required the results of a particular district.
Yes.
And if the results are not there, then the competent and then a person conversant with the mode of making up the results and why.
That affidavit we are required to file tomorrow.
Hmm.
In fact, that's some information has come. Here, one difficulty we are facing, in fact, what the authorities are facing. The advertisement shows the selection was made district wise. And in item number 46, 89% are there. They are from different districts. From Kolkata.
We had tried to point it out. He says, detect it from the other cases. I will do it as it is. What can I do?
Kamruk, Morigaon, Salsalmara, Dhubri, Kolkata, Dhemali, all are there. We have to collect the data from the district company because the selection was district wide. The notice they are going to give the advertisement itself. So we are collecting the data. We need some time. This is challenging the result which published on 10/11. Appointments have been made. Lordship, we got some time. We are collecting the data.
No, have any appointments been made? Appointments have been made. Now, if the appointments have been made, must we have been based on a cutoff?
That is there.
What are you collecting?
The marks, district level marks are at the district level. And finally, after the oral and it has been done by the SEBA, we are collecting the data as well. That in fact the district level and all the materials we are required. And appointments have been done. If lordship wants that the marks obtained by the selected and appointed persons are required, that we are in one case for two districts I have received. Tomorrow we are filing the affidavit in that case. In this case, 89% are there. In fact,
how many districts?
Lot of.
You see the difficulty that we are seeing. When you file a group case, when you file a group case, that group has to be similar in all conditions. All the conditions of a similarity must be there. Here, an ST category person is also involved. And again, a general category person is involved. There is one from the district of Morigaon, another from the district of Dhubri. Merit list will be district wise. So when all the data come and we decide the case, I will have to decide it petitioner wise. I'll have to find out which district. I will have to find out what is the category. So therefore, the council who appeared before you had withdrawn the unreserved category candidates from that particular list. And he's filing a fresh one only with the unreserved category persons, which will help us take up his list first, his writ petition first to decide. It is your convenience. You have got 87 clients, you type out the name at one go. But when the answer from this court has to come, can we do it in this manner? This is a case for dismissal in the present form. allowing you the liberty to come back category wise of similarly situated persons. We have talked about this for the last 10 minutes. Half the list to go.
Lordship, in my case, Your Lordship, my prayer, Your Lordship, is number 15, Your Lordship. Only for Viva, Your Lordship.
Results
Only
of the
issue of
Viva
Viva,
was
Lordship, not
result
other.
of the
Viva is-
Viva was it has to
Lordship,
come district wise.
Lordship. Viva marks are same, Your Lordship, for each candidate. Viva total marks. for
Viva
each
total
candidate.
marks have come from the
Same.
SEBA only.
Same only.
From Viva district wise or as a state?
Final thing will come from.
Viva. He is satisfied only with the Viva marks. He does not want any other marks.
Can you give us some time? I'll come up. I'll come up because I'm awaiting the instructions for that.
Okay. How much time?
But I,
To your convenience.
In item 55, my friend has to submit the reply affidavit, Your Lordship, as per earlier
Who?
order. Item 55.
In all he will file, in all the cases he will be bringing on the data, either the instruction or the affidavit.
Lordship.
That is what he is saying.
Lordship, kindly give us 3 weeks time.
3 weeks. Today is 12, 26, 5. 12th of March or maybe 19th of March. 19th of March, jagah ase?
Let it be on 20th, my lord.
20, 20.
20.
My lord, in 48 and 58, my lord.
Huh.
Interim is there.
Just a minute. Item number
46.
52, you give 20 March. Then item number 46 and 55.
55.
Mr. Nath, senior government advocate has prayed for some time to come up with the instructions and or the affidavit. Full stop. List again on 20 March.
20.
Yes, sir. What were you
My lord,
saying?
48 and 50, my lord.
Ah,
These are the first pages, my lord. Interim is there.
interim for the 200 posts.
200 posts, my lord. And my lord,
Those we
thereafter
have-
long back, my lord.
those
Appointment is issued, long back.
Huh.
And my learned friend is taking time again and again.
How many candidates are you?
My lord, 200 plus, my lord, 90 and 110, my lord, yes.
200.
There are two cases.
200 candidates and 200 posts have been kept vacant.
202 posts, my lord, another 2 posts of one of my friend. He's also-
Yeah, but the number of candidates who had, in those cases, you have got the interim in your favor.
Yes, my lord. And my lord, what happened?
They have filed the affidavit.
Yes, my lord. Affidavit is filed.
Your reply is
Reply
filed.
filed, my lord, attempted to be disposed of, my lord. Now, my lord, they have filed 2 IAs on maintainability, my lord. Long back, but it is not yet been listed. Kindly see the last order, my lord. Last order in my item for.
Why do you speak about the maintainability, sir?
Because of while lordship, we need to produce the records. But while producing the records, we are facing a lot of difficulties as well as they know that these persons are appointed, selected persons are there. Nobody's before your lordship.
You have not implemented the
No.
selected candidates.
My lord, it
Already
was
the
long
posts
before
are
that, my lord.
Huh?
The order was long before that, my lord.
Long before what?
Before the appointment, my lord.
You appointed during the pendency of the litigation.
Yes, my lord.
Yes.
Now you want them to impute all the persons.
My lord, only to.
You have done something during the pendency of the writ petition.
We have other points.
Item number 50.
Let us take up, should we dispose the IA today? Or should we?
No, lordship may keep it along with the
Okay,
other matter.
20th of
Yes.
March.
My lord, short date, my lord, the long
20 March.
My lord.
Their interest is protected.
In item number 50, lordship, we filed an IA lordship in item number 50, lordship, that was correct.
You are appearing for?
For lordship, for impediment of us lordship as a party respondent in.
That we can allow.
My lord, as my learned friend is saying to
Because
collect
lordship,
data, my
we are
lord.
fully
Quite
qualified.
incorrect, my lord. Everything is there.
এখন IA number কি মান?
IA number 3845,
3845 Duke.
2025. For
Any
impediment,
objections,
we
government?
selected in all.
Are you objecting to it?
I'm not aware of the IA. Otherwise,
They are selected in all lordship tests.
Has
But
notice
due
been
to-
issued in the IA?
Yes, lord.
Notice has been issued.
No notice, lordship.
Let
This
me
is-
issue notice today. Let it come to notice. Government does not even know
lordship.
My
that
lord,
there is an IA.
I am supporting because lordship, we are fully qualified lord in all 3 tests, lordship.
You will
And
come
now
in
due
as
to
respondents. Now you will come in as respondents.
As a respondent.
Ah.
Because possibly because the 200 posts we have
Yes,
kept,
lord.
they are not appointed.
We lordship deprived lordship because of that 202 posts. So that we are also required to be hard lordship. Because we qualified otherwise, Lordship, and even they were not qualified.
This is the. What is your IA number?
IA number 3845, 2025.
3845. 2025.
50, item number
Huh.
51 in WPC 3172 2025.
This is an IA for implement of the applicants and party respondents in the connected WPC number 3172. Full stop. This was filed on
3172.
26th of November 2025. Full stop. The applicants have stated that. Why are you required to be heard?
Because we are Lordship passed all the three tests, Lordship. And now waiting for appointment, but due to Lordship keeping vacant of those 202 posts, Lordship, we are not appointed. Lordship, otherwise we are selected, Lordship, in all the tests, Lordship.
You have got the select list.
No, Lordship, we passed every test, Lordship.
The applicants submitted, they have passed all the
Tests.
required tests. And yet, because of the pendency of this petition and the interim orders operating, they have not been offered appointment. Therefore, they are necessary parties to the petition. Issue notice. Please tell us who appears for whom. Mr. D. Nath. Appears for the opposite party number. Kindly help us. Help us. Who are the respondents?
Respondent are the present writ petitioner, Lordship, in item number 50, Lordship.
I am for respondent number 99, 91, 92 and 93.
91, 92 and 93.
93.
Full stop. Have you received a copy of the
No, my lord.
IA?
No, ma'am.
Then we'll ask you to take steps by registered post, by speed post AD on the rest of.
Served, Lordship.
On whom?
Yeah, copy already served. Without serving the copy, it could not be.
If you just, if my learner is saying so, my lord, maybe.
Perfect.
Copy for the.
50, that is not 50.
Extra copies of the IAB served upon the on Mr. So-and-so learned counsel who is appearing for the petitioners in WPC number 3172 of 2025
and 1902, my lord.
and one. This is not on 1902. This is only in 3175.
317.
Yeah.
Stop. List again on 20 March
Same day, Lordship, keep
on
same.
20 March 2026,
Lordship.
allowing the non-applicants to file their objections, if any, to the IA. In the writ petition, 3172, list again on 20 March 2026, along with the IA. It has been submitted that the pleadings are complete
My lord,
in the writ petition. Yes.
my lord, regarding for the 48 and 49, 50, my lord, perhaps 47 also will also with me. We were three cases together, my lord.
Interim order passed earlier shall
That
continue.
is there, my lord. This was the what happened, my lord, in the month of September, perhaps, my lord, blanket stay was there. Then my learned friend came in the vacation court, emergency basis to issue appointment letter.
A writ petition conduct.
My lord, only
Eta matter baki ase.
I'm asking only for short date, if possible, my lord.
Hmm?
My learned friend is delaying the matter, my lord. Try
No,
to
no,
play only the matter.
no, not at all.
Because long back
Not
they
at
have issued the
all. Not at
letter
all.
in the month of.
Not at all.
We'll do it today. Those two writ petitions we can do it.
No, my lord, IA, if I have filed, my lord, if the IA is to come only, my pair will be there, my lord. They have questioned the maintainability, my lord. So the IA mails come in a short date.
No, if we hear the writ petition, we know whether it is maintainable or not. We'll take up the ground of maintainability on the writ petition.
No, my lord, only, my lord, short date may be fixed, my lord, and Mr. MP will appear, my lord, because senior Mr. MP Chaudhary is in this case, my lord, he will appear, my lord. And today he has not come.
We have given you 20
IA
March. When do you want it?
I don't know.
When do you want it? Choose a date. Pick a date.
My lord, this is
Seriously pick a date.
after your logic, come to give.
Let
No,
let it be on their.
When we made a choice, you want a preponement. Everybody is waiting. 4:10 in the afternoon. Give us a date. Please tell us a
My
date.
lord, kindly then, my lord, only that, on that date, my lord, attempt will be made to dispose of.
Have you seen us not attempting to dispose
No,
of
my
the
lord,
matter? Just
lord,
tell us in
sometime,
which
my lord,
matter we have attempted not.
Sometimes
to
it goes to
dispose.
other courts, my lord.
Lordship,
Other
This is the Gauhati High Court, sir. There is no other court. This is the Gauhati High Court where
My
you are
lord-
standing.
My lord, not.
Please do not break it up into courts and courts and courts.
No, my lord.
It
that,
is
my
one
lord.
court.
I'm saying it sometimes it goes to my lord.
Lordship.
Sub 20 much. Your next to the color do. Every piece on me land over.
তোমাকে প্রবলেম আছে?
Something. Dear, I get us. Mr. Das, you were waiting for some particular matter? 30?
Yeah, in this series, my lord, I am in 51.
Ah,
51 affidavit not filed.
we are taking it all up on 20th of
20th.
March, 20 March.
No affidavit filing.
And have they left?
In my case, no, Ms. Sharma, it's
Mr. Nath, Mr. Nath, item
51.
affidavit or record, whatever you have to,
I have
20
to-
March,
I have to, yes, Lord. This is, Lordship.
20 March.
I have to file affidavit here.
Kindly ensure
Lordship.
whatever,
This is in fact not constable. This is for the post of cook, separate advertisement, but it is clubbed together. I am awaiting instruction in this case also. I'll file in time.
20 March.
Lordship, item 54 also replies are waited. Item 50.
In every case, there'll be an order
My-
to them for filing the affidavit so that it can be taken up in 20.
My difficulty is the record again in all the cases. I'll get it by.
Kindly.
Of
Yes, sir. This one.
And the time will not be punishment alert.
What is the matter about, sir?
In your Bank of India, my lord, now it is merged with a Punjab National Bank, my lord.
Hmm.
So on the last occasion, somebody appeared on behalf of the bank and she was directed to produce the original record of the disciplinary proceeding. But that original record will be necessary for the purpose of for final disposal of this petition, my lord. It's a dismissal, the petitioner was dismissed from service, my lord, after holding an inquiry proceeding.
We will not have the time to go for a hearing today. But kindly take a date. We'll fix it on that day and we'll.
Let it be on 20th month. Another matter is coming before Lordship on 28th
Of this month.
of this.
Of this month, we are
That's it. I leave it to
let
your
it do full any hearing day on March
My lord,
to your convenience.
any day, that's it.
26th of March.
March.
26th of March, paucity of time doesn't allow the matter to be taken up today. List again on the 26th of March. A2. Item 35.
34.
34 and 34. A2 key hai?
Obliged to Lord.
Item 34 and 35. Only 35. Yes. I can see.
Item 16.
Hmm? Yes, madam, his case was pending
Yes, Lordship, that I know.
and therefore now it has to go before the rejection is set aside and everything will be reconsidered. That was the single judge's order.
But this was also when they have challenged the 18/9/2024 order, Lordship. This also has to be noted. They have not challenged this one. All these cases where Lordship 18/9/2024 notification was challenged, Lordship.
And are pending, Lordship. And are pending.
And here Lordship SLC already decided,
my
Lordship, it doesn't. SLC decides, so they have come against the order of the SLC, Lordship.
Okay, we'll pass orders.
Lordship, and
So
during the
this cannot be, Lordship.
SLC has already taken a decision.
Yes, Lordship.
The length of time which has already left.
Lordship, during that, my case was also pending, case is
No.
pending, Lordship.
But
How can
it-
I challenge
but-
that?
But challenging the order of 18/9/24, Lordship.
18/9/24 was an order where the 3 years. No,
No,
what was 18/9?
18/9/24, Lordship,
that is-
there no further compassionate
Compassionate
appointment, Lordship.
I have the.
This was their Lordship. But here it is not challenged. There are many cases, Lordship, who has withdrawn and challenged this, Lordship. And Lordship, this is also in respect to Lordship, which cases were pending before either before the DLC or before the SLC. And there was an executive instruction calling to file an application before the appropriate authority where the cases are pending for consideration, Lordship. So these are, it cannot be in par with these cases, Lordship. এটা কি order দিয়েছে? Yeah, before the DLC and SLC, it were to at that line.
Pending in the High Court.
As on before.
Let's say pending on the High Court person, not before the district level committee and state level committee. Lordship. That is the order, Lordship. Gauhati High Court.
আরে এগুলো চেক হবে।
আপনি কই FLC pending কেনেকে হবে? Cases which
Now
are
it is
pending
almost
before
a
the-
year, Lordship,
that is the-
passing of that order, Lordship.
Not before the district level committee or state level committee. Lordship.
We'll pass orders.
They cannot come with
Dispose
this
of-
at
pass
with
orders.
this, Lordship.
You'll pass our orders.
Lordship.
Disposed of.
Deeply obliged.
Orders, again, 29.
Here is the order, last order, my lord, but no effect has been.
Lordship, today, just a few moments back, I have received the instruction. Lordship, just take 2 weeks time, Lordship.
The earlier
Some amount
orders of
required
this
from
court
the
have
requirement.
recorded that the respondents were required to file their affidavits without any further delay. The order dated 31/2026 reflects that the respondents were permitted to file their affidavit in the matter on or before 31/2026. The matter was listed again today. On 31/2026, no further time had been sought for by the respondents to file their response. So now what do you see?
Lordship, just now I have received it. Just a last chance, Lordship.
List this matter again on the 6th of March 2026. Respondents may file their affidavit in opposition on or before 27th of March 2026. Non-filing of the affidavit on or before 2/27/2026 would lead this court to infer that the respondents are not serious about contesting the case. Affidavits filed after 27/2/2026 shall be accepted only on payment of cost of ₹2,000 in favor of the Assam State Legal Services Authority, Old High Court Plus. List again on 6th of March.
Obliged.
Notice as per optic not service report is still awaited notice. Notice this is a contempt case, Lordship, and the respondent is the director of secondary education. Notice this is a contempt case, Lordship. And
Anybody in the secondary education department? Yes, Mr. Sharma.
Okay.
You are required to dispose of a representation by
passing is.
passing a speaking order. Kindly give him a copy.
Yes, Lordship.
When can you have the instructions?
After 3 weeks, my lord, in the meantime, we will file our Okaladnama also, my lord.
The service report on the sole respondent is awaited. Mr. U. Sharma, Learned Standing Counsel of the Education Department, has been requested by this court to have instructions as to whether the final decision in the joint representation required to be submitted by the petitioner has been taken or not. Awaiting service report. List this matter again on the 9th of March 2026. Most of the name of Mr. U. Sharma will be reflected in the cause list for convenience.
Obliged.
41.
Location DSM. I take the Xerox copy to someone. One number to look.
Lordship, can we tell you the last order?
Lordship, there
In this case, my lord, may I say? In this case, my lord, I have taken justice service in regards to the 3 and 4, but till today nobody has appeared. So let them come, my lord, because I have filed justice service.
We should allow them some more opportunity to come.
Yes. Let them come to say why they have
Ah,
not.
we will wait for them to come. Let them come. You see. We'll wait for them to come.
Yes, yes, next date.
Next day.
Lordship, here I have applied for respondent number 6. We'll be filing our affidavit by Tuesday, Lordship.
But I have not received.
No, no, we'll be filing.
Oh, you'll be.
You are 3 and 4.
I'm for 6, Lordship.
6. Who is 6?
Lordship, finance.
Secretary. 5 stuck off.
This
1.
case is non-payment of pensionary.
Anybody
Very
for BTC?
unfortunate.
No, Lordship, the direction.
What was the director? What was the direction?
Direction was to give the petitioner the benefits of old pension scheme.
Old pension scheme.
Now, the authorities, we are in our, for finance department, we have not received a proposal, Lordship, that is what we have stated in our affidavit, that will be filing by Tuesday.
That has to come from the BTC authorities. From the BTC or from the respondent number 3 and 4?
Yes.
3 and 4.
Or from you?
Inspector of school.
You are appearing for?
The direction.
Director.
So we'll ask for the personal appearance of the director because she has not found out what has been done by the inspector of schools.
Yes, yes.
She's an employee over whom you have got supervisory control.
The director has only called for a report from the inspectors.
But calling for a
That's submitted a report.
Hmm.
And the director has sought instruction from the government. Because
so we'll ask the government to
we have entered a bit on petition and our agriculture.
At least let them come under in regards to 3 and 4, because 3 and 4 is not yet appeared. So
Yes.
I have already been take justice service, my lord. This is the 3rd day.
heard Ms. K. Devi Learned Counsel appearing for the
That's-
petitioner. Also heard Mr. A. Choliha,
Respondent number 6.
number 6, who has stated that they will be filing an affidavit during
By Wednesday.
will be filing an affidavit in response within a period of 1 week. Mr. B. Kaushik, Learned Counsel
1 and 2.
appears and submits. Appears for 1 and 2 and submits that they will be filing the response within a period of 2 weeks. The none has appeared for the respondent number 3 and
3
4,
and 4.
although the earlier order records that the respondent number 3 and 4 have been served.
So,
Have been served. Full stop. This court had also recorded that in the absence of a response from 3 and 4, the court will be constrained to pass appropriate orders to ensure presence before this court. In such view of the matter, registry is directed to issue summons or what? Warrants, no? To issue notice to the issue a summon to the respondent number 3 and 4 to be routed to the officer in charge of which police station?
Baksa.
Officer in
Ushanpur.
charge. Huh?
Director Kokorazar BTAD.
To the concerned police, concerned officer in charge of the police stations.
Baksa, Botra
List
Baksa.
of the report of service of the summons through the police station be placed before this court on the next step of listing. List again on 19th of March.
March.
अच्छा वो summons जो लिखी से summons requiring the personal appearance of the Yes.
Before the court.
Yes.
My lord, the challenge is here, my lord, the dismissal order of the petitioner, my lord.
Do we have the time today?
Some
Yes, my lord.
Yes, some
Second-
reports.
Been received, Lordship.
Hmm.
And
What do you
Lordship,
find?
Lordship, everything was done as per procedure only, Lordship.
Yes.
He was issued the first show cause notice, he replied to that.
He replied to the show cause. Then what happened?
Then second show cause was noticed along with the inquiry report. He
Now,
made
where
a
is the-
representation.
Where is the second inquiry report?
That
Second
Lordship,
show cause?
petition, if the petition does not have the.
Records have it.
Yes.
Show us kindly.
Record too.
Where is the second show cause? কি হলো এখন? টাকা পেলে কি ব্যাপার?
Lordship, I flag marked. It's from the last to the first. Second show.
We are setting it aside from the stage of the second show cause notice. I have gone through the relevant records and I agree with the findings of the inquiry officer and hold the charges leveled against you to be proved. Please find a copy of the inquiry report, whereafter I shall punish you.
No, Lordship,
is the
major,
use?
as to why he has to show cause as to why a major punishment shall not be
Yes.
inflicted upon you,
This is the first time you are giving him the inquiry report. Is it not?
Lordship.
And before giving him the inquiry report, you are holding him guilty
No, Lordship, he was asked to make a representation after
on
that.
the punishment, not on the inquiry report.
Yes.
I have gone through the records
Lordship.
of the inquiry submitted by the EO. I agree with the findings of the EO. What is the purpose of giving a inquiry report to a delinquent official?
To make a representation.
Against what?
Against the inquiry report.
Now, the discipline authority is saying, I am agreeing with him. So now you tell me why not? It will be like I agree with the writ petition. I am telling you, yes, I am allowing the writ petition. Why should I not? Will you agree to that proposition? No. You will say, sir, listen to me, then you decide. Is it not?
Lordship.
This second show cause notice needs to go.
And the charges also leveled against him are grave charges, Lordship,
No,
of extortion.
we'll give you the full liberty to hold, to give him the inquiry report first and then decide whether he is guilty or not.
Inquiry report was served upon him, Lordship, like this.
While serving it, you hold him guilty.
No, Lordship, he was asked to make a representation. On his representation being found not satisfactory, after that, Lordship, he was dismissed from his service.
Yes.
My lord,
Any judgment? Quickly.
my lord, the representation, my lord, the reply is not available in my writ petition, my lord. My lord, kindly come to page.
I have the records.
23, my lord. In my writ petition. The order of the appellate, my lord, appellate authority. 3 lines order, my lord. Page 23.
Page?
23.
Page 23 of what?
My writ petition.
No, of your writ petition.
Yes. May I read, my lord? The appeal petition received dated 5/5/2016 with reference to the above, the files and related documents.
You want
of
this appellate order to be set aside?
DP, my lord, drawn up against you has been consulted thoroughly and agree with the conclusion of authority concerned, that is the Superintendent of Police Shipsagar. Hence, your appeal petition could not be considered. This is the order of the appellate.
So we should set it aside. Should we set it aside?
Yes, yes.
Now, once we set it aside, your appeal will be reconsidered. You're satisfied with that? Okay, we'll set it aside now. We'll simply set aside the appellate order, send it back to them to pass a fresh order on your appeal. Will that do? That will do, sir.
This is the order.
What do you want us to do?
My lord, the appellate authority, my lord. Only, my lord.
No, we hold that the appellate authority has passed a very wrong order. Now, what do you want? What is your prayer?
My dismissal order may be set aside.
You are showing us the appellate order. Challenge the dismissal order. Show us some mistake in the dismissal order. I will set aside the appellate order right now. This matter again.
My prayer is also, my lord. My lord, the order of the.
You are arguing, you have made your submission on the appellate order. You have not made any submission on the.
Both, my lord. Both, my lord.
Lordship, during the inquiry process, he has admitted to his guilt, Lordship. He has admitted that he was present at the PO to help the criminals when the crime was being committed.
He was at the place of occurrence.
Yes, Lordship.
My lord, taken up with my lord on another date, my lord.
Tell us a date.
Other date.
Tell us a date.
And, my lord, I may allowed to go through the record.
Tell us a date. The records as called for by the earlier order has been produced by
27th of February, my lord.
Ms. U. Sharma, Learned Counsel appearing for
For all the respondents.
for all the respondents. Mr. So and so, please for the matter to be listed on
27th of February, my lord.
February, no, something in March.
My lord, miscellaneous day, my lord, on 10th March, my lord.
On 10th March. 10th of March. Ms. Sharma shall retain the records which have been requisitioned. 10th
My
of
lord,
March.
I may allowed to go through the record.
To dispose of matter. Today not.
On the next date.
On the next day. Before the matter is called for, go through it. Allow him. It's an old matter. Yes.
Obliging.
36.
36.
In this letter.
Just tell us if it needs some urgent intervention or if it can come up in March.
Yes, ma'am. Yes.
In the 21st/07/2017, of this, there is an order to submit the record. Today I have
Receive the records. You have received the
I
records.
have received the record, but unfortunately everything is in Hindi.
Kindly tell us. We are conversant if you are.
Oh, that's no issues. So your lordship wants it, then I can get it elsewhere.
It would be better if you can get it before the next date fixed.
That may be recorded.
But otherwise, no, it's up to you. It is up to you to get a. Otherwise, we can simply say that we are not conversant in Hindi. This court does not allow Hindi. Records are not accepted. Yes, argue on the matter. It's up to you. We are not passing any orders. List this matter again on the 17th of March.
Last week of March, no, last week of March, man.
Last week of March.
Yes,
Last date may be given then in case.
24th, 31st,
No, no.
24th, madam.
No, 24th, I'm having a case in
31st,
So let it be on 31st.
not 3031.
3-1.
31st of March, the records have been received by Mr. Waidule,
Yes.
may be retained. And appropriate copies may be made for production before this court.
Yes. Obliged.
Officer.
Anything urgent?
My lord, it's a all pending, but that may be fixed. my lord,
Understood,
because
but what is the matter about?
My lord, the removal from the service, see, SSA employee, departmental proceeding was conducted. First, removal was simply that was intervened by the Honorable High Court. Then second, and then he has reinstated, then second. My lord, there is a lapses and something.
26th of March?
26 months, yes, yes.
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 39.
Is taken on 26th of April at the consent of the parties. Huh?
Yes, Lordship. Matter pertains to the poor red ink entry, my lord. So this very old matter, my lord, so date may be given, my lord.
You would not be filing any reply. They have filed the affidavit.
My lord.
You have not filed a reply. We'll close the chapter there.
This is
We'll take all the affirmance made in the affidavit in opposition to be true and correct because they have not been rebutted. Yes.
I will file.
I'm just trying to think what would happen.
My lord, I will file, my lord.
Huh?
I will file it over this covered.
List the matter again on the 31st of March 2026. Although the matter is listed in the hearing column, the petitioner may file his reply.
My lord, declare it.
Yeah, okay, ma'am.
My lord,
Yes.
my lord, this matter may be taken up any other day.
Any other day, but my lord, lordship will give a short date, and if possible, my lord, add to some observation. My lord, in the meantime, the petitioners have been promoted.
But his grievances are
For
still
retrospectivity.
pending. My lord, what happened, my lord? I am asking for seniority.
Huh.
And now they want to give the promotion to the private respondent from 2023.
He is saying that have it on an early date.
Yes.
And fix it at 2. I see urgency in his request.
Fine.
Ekdom earliest কেতিয়া দিব পাৰি?
Lordship will see the board also.
I would not be having the list. I may not be having the list.
As per your lordship convenient, it may be fixed.
10th March. 10th March.
We have some urgency, Lordship. It is respondent number 7 whose promotion has been stayed.
Yes.
Petitioner gets his promotion. He enjoys his
All,
promotion. I'm being debarred to.
Mr.
get my
H. Betala has submitted that there is urgency in the matter. Good stop. List this matter again on the 10th of March. It is provided that in case the writ petition is in case the writ petition fails, respondent number 7 would be entitled to all consequential benefits. Should we record that? You know it as a matter of course.
Not wisdom, Lordship.
You know it as a matter of course.
That liberty, my lord, if at all possible, we will mention it, my lord, lordship.
Liberties to the parties to mention
At 2, Lord.
on the said day for an upgradation.
Upgrade, Lordship. I'm so grateful, Lord. Highly appreciated.
Problem.
None appears for the parties on call, comma. Perhaps since the court hours are over. List again on. What do I? March of did you get hearing data under the same column. 24 March total. 24 March. 44. You're paying? What is the matter about? What is the matter about?
The petitioner was unauthorized, is on unauthorized leave, lordship.
He has been terminated.
Yes.
Compulsory terminate. 2024. Paucity of time did not matter. Did not allow the matter to be taken up today. List the matter again on 26th of March.
Much obliged, lordship.
Have you filed your affidavit?
Yes, lordship. We have filed our.
Lordship, here I gone through the record, Lordship, original record. The petitioner was asked to whether he wants to cross-examine Lordship. He simply denied to cross-examine. And Lordship, apparently it is seen that Lordship, the witnesses has cross-examined him, Lordship. This,
I think it has to be.
this is their Lordship.
So we'll say that the records as required by the earlier, did we ask for the records?
Yes, my friends have.
Rakesh, no, Lordship, and long back it was asked, Lordship. Long back it was asked.
The records in this case are have been received. The matter was heard at length on 7/2/2026. Arguments concluded today. Judgment reserved.
Lordship.
Lordship. Lordship, do I need to?
Yes, the records produced by Ms. Bhattacharjee, learned additional senior government advocate, be retained with the records of this case till delivery of judgment. We are retaining it till delivery of judgment. That will help you because at times the records, if misplaced, this order will help you later. Yes, sir.
Lordship, sorry to make a mention, item number 23,
Ah.
exactly, I was next,
Hmm.
that remains unrepresented. Now, what has happened, Lordship, is a promotion matter, that it has been fixed on 30th of April. Can it be a
Ah.
little bit early, Lordship? I've informed the council for that.
Okay. Choose a date.
Any day in the
Choose
first-
any date in April or even March. Okay.
in
Is
the
it,
middle-
it was for admission?
For admission. I'll file my reply on.
30 March করে দিও 30 March করে দিও Can it be corrected? I have
23.
not signed the order. Correct it. Huh? 30 March. Huh?
23.
Item 23.
23. I'll file my reply, Lordship, there.
30,
30th of
31.
April.
It was already fixed on 31st of March.
31st.
Item
Can it be
23.
Little bit early, Lordship.
March.
because-
From April you wanted March. Now I've got it for March.
No,
Yes.
I'm saying about the second week of March or third week of March. Because there's some urgencies there, they're going to fill up the post, Lordship.
9th.
9th of March.
9th of March করে দিও পুরো
23. এটা 30th of April করেছেন আমার জীবনে। 28, 28, 28. 20, item number 28.
28.
8.
হ্যাঁ হয়ে যায়
30th of April. Probably it is.
এইটো 31st থাকিব 28 টো কৰি দিও কিমান আছিলে 30 এপ্ৰিল আছিলে
30 April.
মেক ইট 9th এপ্ৰিল 9th মাৰ্চ 9th মাৰ্চ হ'ব কৰিব পাৰিবা
Alright.
Thank you.